Um, Good morning, and thank you all for joining us today. We at CLPR, the Center for Law and Policy Research, are happy to welcome you to the third workshop in the US-India Comparative Constitutional Law 2.0 series. The Center for Law and Policy Research is a not-for-profit trust dedicated to making the Constitution work for everyone through law and policy research, social and governance interventions, and strategic impact litigation. This project is in furtherance of our efforts under our Constitutional Culture Initiative. This initiative is aimed at creating public awareness and enabling active public engagement with India's constitutional tradition to build a popular constitutional culture in this country. Over the years, the initiative has expanded in scope to include websites, public events, and conferences. Our constitutionofindia.net website curates debates which took place in India's Constituent Assembly leading up to the framing of our Constitution. The website also hosts historical constitutions which document constitutional aspirations prior to the formal Constitution framing period. We also have biographies of Constituent Assembly members, succinct debate summaries of the articles of the Constitution of India 1950, and the website also has content that engages with India's constitutional past with a peg to contemporary social and political events and issues. We encourage students who are interested to visit the website to read, search, and explore about India's constitutional history and practice. Apart from this, we also host an annual quiz known as Conquest, which is a national quiz on the Indian Constitution, politics, and history. We held this in an online format last year due to the pandemic. We have also organized numerous impactful workshops and events aimed to impart constitutional education in schools and colleges. We have expanded our awareness initiatives this year to include merchandise and multimedia content. We have designed label pins and a preamble t-shirt. And in light of the 75th Independence Day this year, we released an animation video on the making of India's Constitution, which tells us the story of how we Indians gave ourselves the Constitution. Now, coming back to the workshops itself, the purpose of this project is to help students understand and appreciate the constitutional traditions of India and US. And through these sessions, we aim to significantly, increase engagement and appreciation of Indian and US constitutional law and facilitate collaborative constitutional understanding and exchange of ideas and perspectives among Indian law students. We would like to thank the VC of Tamil Nadu National Law University, Professor Dr. V.S. Elizabeth, and Professor Dr. Vishnu Prasad for partnering with us for this workshop. We're also extremely grateful to the US Consulate General Chennai for all their support. We have with us Ms. Usha Davalu from the US Consulate General Office. Usha is the grants officer representative, and she has been supporting us throughout the process of planning and executing this event. Usha, we're happy to have you with us today. Please share a few words.
Thank you. And on behalf again of the US Consulate and CLPR and our host, Tamil Nadu National Law University, we are really thankful and we appreciate the presence of all students in this workshop. I know we have gone through a very bad weather and the cyclonic effect, and despite all that, you've taken the effort to continue with this program, and we really appreciate that. And again, we are so happy after 2 years, we were there in person in campus to conduct the constitutional debate 2 years back, when everything was okay in 2019, and it was such an exciting time to be at the university and be with the students that day. And thanks to CLPR for putting such a wonderful content on the US and India constitutional law. We have done this a couple of weeks back with the Ambedkar University and with the Nuwals University, and we really think this will generate very good discussions looking at both the constitutions. And we are so blessed, I think, to have our own constitution, and we are a democracy, and I think this discussion between the both the democracies, how we went about doing this constitution, facilitated by CLPR, is going to be extremely helpful to the students, and we look forward to hearing from you. Thank you again, Meenakshi.
Thank you, Usha. Thank you so much. We're really looking forward to the sessions we have planned for you today and tomorrow. So today we will have 3 sessions. One on constitutional founding, where we'll take you through the constitutional stories of India and US, followed by the second session on personal liberty and freedom of choice. And finally, the third session on reproductive rights and personal autonomy. This will be followed by a summary session and on-spot essay competition in tomorrow's session at 9 a.m. The top 2 essayists from this competition will be invited for the grand finale in Bangalore on December 11th, 2021. So maybe we will just to give you the framework of how the sessions are going to be, the sessions would flow over today and tomorrow. So maybe I will just stop here. We can take a small break for about 5-10 minutes, and maybe other students could also use this time to join in. And we will reconvene for our first session on constitutional founding at 9:30. Request you to please text your friends who haven't joined, who have registered, so they can join in by 9:30 for the first session. Thank you. I just thought I'll let you all know that if you have any questions during the session, please raise your hand, put your comment down in the chat box. We'll be happy to take it up. And otherwise, also we have a dedicated time slot for question and answer. So please feel free to raise your questions then as well. Okay, maybe I will start. It's 9:30. So this is our first session on constitutional founding. Before we start discussing the values of our constitution, we thought it is important to know and understand how the 2 constitutions came into being. And this will help us appreciate and analyze law in context, which is useful and relevant in comparative studies. So I thought I'd first take you through the agenda for this session. We will be having 2 parts to this session. The first part, I will take you through the readings of how our constitutions came into being, followed by a short Q&A and student discussion for 30 minutes. And then we move to part 2, where we're going to be looking at 2 primary texts, the Constituent Assembly debates in India and a letter by Alexander Hamilton to understand the concept of due process in the 2 countries. Then we will have a short Q&A after that. If any students have any questions on the readings, please feel free to raise it then. And then we will move to the student activity. This will be finally followed by Dr. Amal Sethi's remarks on the constitutional founding moments in US and India. And then we will conclude this session with that. So many constitutions have had an impact on the Indian constitution making process, particularly the US Constitution and its constitutional founding moments. Nehru actually acknowledged this as inspirational value of the American Constitution and its founding when he introduced the Objectives Resolution in the Constituent Assembly. He said, and I quote, "I think also of the various constituent assemblies that have gone before and of what took place at the making of the great American nation, when the fathers of that nation met and fashioned out a constitution which has stood the test of so many years, more than a century and a half, and of the great nation which has resulted, which has been built up on the basis of that constitution." Having said so much about the US Constitution, I thought we'll just delve into how the American Constitution came into being. The popular understanding that the American Constitution is that the American Constitution was drafted and adopted in the Philadelphia Convention that took place in 1787. However, there were a series of events that preceded it and succeeded it that informed how the present Constitution we see today. Starting from the Declaration of Independence to the Bill of Rights and the subsequent amendments, let's look at some of these key moments and what influence they had on the American Constitution making process. So let's start with the first Declaration of Independence. To just give you a sort of background, prior to 1775, America was a loose group of about 13 colonies organized under the British. And on there were conflicts on questions of representation in the legislative bodies and increasing taxation. So in 1775, the American Revolution began to counter these conflicts. And almost a year into the war, on July 4th, 1776, the colonists adopted the Declaration of Independence from the British. This document was an inspiration, in fact, for the declaration of Purna Swaraj in India in 1930. And we will look at the significance of this 1930 document when we look at the Indian constitution making process. The key facets of the 1776 declaration were two main things. First was an equality clause, which said all men were created equal. This didn't find its way into the 1787 document. And the second one is that democracy, which is people have the right to choose their government. Now, between this declaration and the 1787 constitution, the colonies were governed by two main documents: the Articles of Confederation at the national level and the state constitutions at the state level. Now, the Articles of Confederation was actually drafted by a 13-member committee that sat from November 15, 1777 to November 20th, 1778. What these Articles of Confederation did was create a national government which had a legislature, no executive, and no judiciary. And essentially, each state had one vote irrespective of their population. The national government had no power to tax or regulate commerce between the states, and the national government couldn't call troops from the colonies in case of armed conflict. Any amendment to the articles required a unanimous approval of all the states. Essentially, what this did, it created a very weak national government that had no control over how the states organized themselves or conducted themselves. So in 1783, when America won its independence, they couldn't continue with such a weak national government. And so what happened was, due to these shortcomings, Hamilton in 1786 proposed that the articles should be amended to provide for a stronger national government. This proposal was endorsed by the Confederation Congress in February 1787, and it requested 13 colonies to send delegates to a meeting in Philadelphia, which the Philadelphia Independence Hall, where the Declaration of 1776 was adopted. So on May 25th, 1787, 55 delegates from 12 colonies came. Rhode Island didn't send any representative. And these were predominantly white men who were aristocrats, slave owners, lawyers, etc. George Washington was unanimously elected as the president of the convention. Now, the initial scope of this convention was to amend the articles to have a stronger national government. But things changed, and they deliberated on instead of having a new form of government itself, with three distinct organs, that is the legislature, the executive, the judiciary, and have a robust system of checks and balances to ensure that each organ does not exceed its constitutional mandate. So finally, in September 1787, five members of this convention, James Madison, Hamilton, Rufus King, William Samuel Johnson, and Morris, drafted the Constitution. It had 7 articles, a short document, just 7 articles, setting up each organ, that is the executive, legislature, and judiciary, and declaring the Constitution as the supreme law, laying down the amendment process, the ratification process, and the relationship between the states. So now that this Constitution was adopted in September 1787, there was a requirement for the Constitution to be ratified by each of the 13 colonies. This ratification process started in December 1787 and ended in May 1790, when the last state, that is Rhode Island, ratified the Constitution. During this ratification process, in order to persuade people to ratify the Constitution, both James Madison and Alexander Hamilton published 85 essays on why the Constitution should be ratified and some of its key features. This collection of essays is popularly known as the Federalist Papers. Now that the Constitution was ratified, the first US House of Representatives sat, and Madison, a representative in this House, in 1789, introduced 17 amendments to the Constitution. Sorry, 19, 19 amendments to the Constitution, out of which 10 were ratified by all the states. These 10 amendments incorporated various civil liberties in the Constitution, such as freedom of speech, the right to assemble, etc. And they are popularly known as the Bill of Rights. Now, the Bill of Rights became a part of the Constitution in 1791. Including the Bill of Rights, only 27 amendments have been successfully made to the American Constitution, with the last one being made in 1992. This is the story of how the American Constitution came into being. Interestingly, in contrast, we have a rather lengthy Constitution, which has had about 105 amendments as of August this year. And let's look at how that Constitution came into being through a short video.
We the people, having solemnly resolved to constitute India, battled the British for over a century on the streets and in the courts and assemblies to realize our collective desire for freedom from colonial authoritarian rule. This found an early voice in 1895 with the Swaraj Bill, which demanded a dominion state with equality for all and freedom of speech. In 1928, Motilal Nehru's report went further to call for self-governance and minority rights. However, both demands fell on deaf ears. So on 26 January 1930, the Indian National Congress declared Purna Swaraj, or complete independence, discarding the demand for dominion status. A year later, at its Karachi session in 1931, the INC demanded comprehensive social and economic rights. Sensing imminent change, M.N. Roy proposed a constitution drafted by a Constituent Assembly of Indians, by Indians and for Indians. The INC embraced this view, and after years of relentless negotiations with the British, a Constituent Assembly was created in 1946. Nearly 300 members, representing all shades of political opinion, diverse religions, ethnicity, and from all over India, met in the plenary assembly and subcommittees across 3 years to draft India's constitution. They made deliberate and radical constitutional choices to first, transition India from a colonial authoritarian state to a constitutional democratic republic, with adult franchise and representative legislatures and independent courts to maintain the rule of law. Second, to transform a traditional society built on caste hierarchy and patriarchy into a modern egalitarian society based on every individual's dignity and fraternal relations between them all. Third, usher in a multi-religious secular democracy by assuring individual freedom of religion and keeping the state away from organized religion. And lastly, to restructure a feudal economy based on concentrated or inherited wealth and large landholdings by distributing land and other economic resources and ensuring social and economic welfare. Finally, this new Constitution Republic was born on 26th January 1950. 7 decades later, our Constitutional Republic needs you to be a Constitution defender, to preserve, protect, and realize the progressive constitutional dream to build a new India.
Thank you, Kalyani. So if you could share the screen, the slides, please. Yeah, so now we have gone through the constitutional stories of India and US. With this, I'll just start with asking if any of you have any questions. I'll probably give you 2 minutes to ask me any questions, and then we will move on to the discussion. Okay, maybe some questions would come up during the discussions itself. Otherwise, please feel free to put in your questions in the chat box and we'll definitely pick it up, or raise your hand if you have any questions during the session as well. Okay, then we can proceed with the student discussion. So, yeah, the first discussion question we wanted to ask you is, should constitutions be made democratically? Do any of the students have any comments on this? I see a hand raised. Yeah, Hari Krishnan, please feel free to speak.
Good morning, ma'am. Am I audible?
Yes, we can hear you, Hari.
Yeah. So should constitutions be made democratically? On that, I would like to refer to the Constitutional Assembly debates itself, in that we saw many of the issues that came up in regards to the representation in the national legislature, or any other issues regarding the terminologies which are being used in the Constitution. The variety of opinions that came helped shape the Constitution and make it what it is today. So yes, in my opinion, Constitution should be made democratically, following the processes that have been followed by democracies that were established long before.
Thank you, Hari. Do any of the other students have anything to add to Hari or to respond to Hari?
Good morning, ma'am. Am I audible?
Yes, Pratibha, I can hear you. Please speak.
Yes, ma'am. To add on to what Hari has stated, I think constitution should be made democratically, because if we see, constitution is that supreme document which governs all the people. So in situations not just related to constitution, but any document which governs everyone, I feel all the citizens should be involved in making of that particular document, and their opinions and ideas should be taken into consideration. And talking about the making of the procedure in which a constitution was drafted, in addition to the opinions which we got in the Constituent Assembly debates, one other process which I liked was that after the draft constitution was compiled by Mr. B.N. Rao and it was sent to the drafting committee gave it out to the people, and people who were there in India at that time, they gave their suggestions, which were deliberated upon again before first, second, and third reading for 3 days by the drafting committee, and then it incorporated those changes. So I feel these kind of steps actually make it more effective for us to understand each and every perspective. Because even though per se we say that legislatures are diverse and they have all kind of people in them, but when we go at a larger level and ask public to give in their opinion, the effectiveness of any document becomes more.
Thank you. Thank you, Pratibha, for highlighting not just talking about the importance of having a democratically made constitution, but also some of the processes that was adopted in the Indian constitution making project. I think there was someone who commented in the chat box. They said, I'm not getting their name, sorry.
It's Amat Rashi.
Yeah.
And they say that, yeah, because the society has different people with different views, it is important that the constitution is in fact made democratically. And I think that's an interesting point with respect to representation. So if somebody wants to talk about that, that would be great.
Ma'am?
Could you please raise your hand so we know who's speaking? That would be easier.
Suvita. Yeah, Suvita, go ahead.
Adding on to the point popped up in the chat box, I think that the Constitution Assembly molded no new sovereign. It merely shaped the aspiration of the people by destroying the foreign control and evolving a completely democratic form of government as a republic. So I think that the process was not of a destruction but of evolution. For the reason already stated, it is impossible to hold that what we mere claim to be property till Jan 1950 could be regarded as enforceable against anyone, but till the domain of India recognize their rights explicitly or implicitly, therefore the India is to be democratically recognized.
Thank you, Suvita. I think someone else had their hand raised. Yeah, I think it's Hari again. Yeah, Hari, go.
Yes, ma'am. I didn't have anything to add on to that, but I did have a question regarding the presentation that you gave. Is it okay if I ask?
Yeah, please go ahead.
Okay, so ma'am, in the readings that you gave, that you sent through the mail and the presentation itself, It was the constitution, debating the constitution of United States and India. In that, my question is with respect to the state representation and national legislature.
Mhm.
We saw in America the Connecticut compromise in which the bicameral legislature was established, and in India too. So, but in that we saw equal representation and proportional representation was given to both the houses. And so my question actually is that we have seen in America gun control, gerrymandering, filibuster. These are issues that never get spoken about in these chambers, merely because there is equal representation and conservatives do not want to talk about it. And in India, with the 2026 delimitation committee pending, we still have that question. Northernmost Hindi-speaking states will have more say in what goes on in the country. So is it actually an ideal system of bicameral legislature that we are following, or is there room for improvement in that?
I actually think this is a great question to start because we're discussing democracy and democratic values in constitution making process itself. And I would actually like students to respond to this because there is no right or wrong answer to this. So if any students have any comments or responses to Hari, please feel free to answer. A good way to sort of even think about Hari's question and connect it to the larger question on how the two constitutions were made itself is looking, and because of he mentioned bicameral legislature and the voice of states in deciding national issues. You can also think about the voice of states when it came to the constitution making process itself. So if any students have any comments on that also, please feel free to speak up. In the meanwhile, I think there are a few messages in the chat box that I would like to read out. Just a second. Kalyani,
yeah, I can do that. Yeah, I can do that. We have someone, Yashwantini, I believe, who has said that it's important that constitutions are in fact made democratically because democracies check legal equality and opinions of different lives of people. So it is important for a constitution that is justifiable to all lives. We also have Ishita, who has mentioned that we need to be on a middle ground so that we don't become absolutely soft to people's unreasonable needs. That is why we need a set of intellectuals who could rationally draft the constitution, keeping in mind the structure of the country and aspirations of people.
Thank you, Ishita. Actually, what Ishita has raised is an interesting point, which is, yes, while democracy is important, when it comes to drafting a sort of legal technical document, what is the level of expertise that we require in the constitution making body, and how do we sort of balance the need to have the sort of a democratically representative body and having expertise on the board? Anyone care to comment?
Ma'am?
Yeah. Aditi, please go ahead.
Yeah. Ma'am, regarding the point that you mentioned that we need legal expertise as well, but I think that cannot surpass or that cannot, under the garb of legal expertise, you can't say that there shouldn't be an involvement of the people or the democratic process. The democratic process per se cannot take a backseat just because there has to be some legal expertise. What I think is should be considered rather is that the document, the constitution, which is the main document of the land, which is the living document of the land, that needs to be representative of the people of that land, that needs to be representative of their aspirations and inspirations. The language, however, can be modified and can be quoted in the legal words or whatever it is, that can happen at the second stage is something what I feel.
Thank you, Aditi. So you're essentially talking about balancing the need to have a sort of democratically elected body and the need to have expertise, and the sort of proposal you've given is that the larger opinions and the larger values should be decided and deliberated in a democratic process, and maybe the drafting or the technical aspect can be dealt with by the expertise. Thank you, Aditi. Yeah. I think there are a few questions before I go back to Hari. I see Hari's hand raised. First is Pratipar actually asked me to repeat Hari's question. So what Hari was asking is how, because of the sort of bicameral system of like having two legislative bodies and one with representatives of the state at the national level, has sort of created roadblocks in implementing a lot of policies, or has in fact given a sort of upper hand to a few states with a larger representation in both the Indian and the American context. So he was generally asking about how we view this bicameral system itself as a democratic process that both the countries have adopted. And I think Suvita after that has said, in a deeply hierarchical and unequal society, as India ahead of the enactment of the constitution turned the idea of democracy into a meaningful and creditable story. Nilavan has also said that even if it is understood that there is a necessity for experts to be the drafters of the constitution, people of different backgrounds ought to be included in the drafting process to acknowledge their needs and their aspirations.
I think maybe that's a great segue for the second question. And
I just think Hari has a quick point. We'll just take that and then move to the second question. Hari.
Hi, am I audible?
Yeah, we can hear you.
Yeah, so I believe the previous speaker who said that it is important for legal scholars to be a part of the constitution, but is also we need to balance it out with the people in a democratic system. To that, I just wanted to refer to the ideas that Socrates put forward, the Greek philosopher, where he wasn't exactly thrilled by the idea of democracy, because he found that if everybody is given the right to vote, sentiments and emotions will start taking place, and it will eventually lead to demagoguery, which was one of the biggest fears of the Greeks. So he also didn't believe in the elitist idea that only legal scholars and people educated should be allowed to vote. But what he essentially wanted was that our effort should be to inculcate everyone with the idea of legal knowledge, and making them understand what it is to vote and what their vote matters. So that is one point that I wanted to raise with regards to the equal representation.
Thank you, Hari. So I think maybe with that we will move to the second question itself. So now we answered the normative question of whether constitutions should be elected democratically. Should be made democratically. Now let's ask the more empirical question. Now that we have gone through the constitution making process in India and the US, have the Indian and American constitutions been made democratically? I see Walter's hand raised. Walter, do you want to go first? It could even be in response to the previous question.
Yeah. Hi, I'm Walter from TNNLU.
Hi, Walter.
Good morning. So I just had a question when I raised the hand. Like as I raised the hand, you were asking the second question.
Yeah.
So my question was, why did the Articles of Confederation fail? I noticed that you mentioned that it gave a weak national government inability to raise funds. All these are consequential reasons as to why they reconvened again in Philadelphia. But were there any reasons like, were those articles drafted by just like one or two people or a particular set of people that caused it to fail? I just wanted to clarify on that.
Thank you, Walter. Maybe one way to look at that, just to quickly respond to it and then move to the next question, is that when the Articles of Confederation were drafted by a 13-member committee, what happened, what they were, you have to look at the context, is that they are fighting their war for independence. They just needed something in place to govern them at that point. So they did just, temporarily, it's maybe, in my opinion, something temporary in their head to sort of just ensure that everything is in place for that time being. And you also had to get all the 13 colonies on board, right, to form a national government. So you cannot possibly give them too many powers or create a stronger national government at a time when they're already facing other internal conflicts. Yeah.
Just to also add to that, I believe there was there were particular economic, leadership, and military problems as well, where initially, I believe all the states were allowed to have their own militia, but the national government was unable to gather some sort of a combined force. And similarly, economic as well, where the Congress wasn't allowed to tax and such. So there were other economic, leadership, and military reasons as to why the Articles of Confederation failed as well.
But my question is, who drafted it?
Okay, so it was actually, a 13-member committee with representatives from the 13 colonies who sat together for about a year, deliberated, debated from November 15, 1777 up till November 20th, 1778, and that's how the articles were drafted.
Okay, thank you.
I've put the second question on the chat in case everyone wants to read it once more, and then maybe take a minute and then reply.
While people are thinking, I just think there's one quick comment in the chat box to the previous question itself by Adrian. Adrian says it's imperative, in my opinion, that constitutions are made democratically, because if a set of laws or rules are set or adopted to rule and regulate the people, then it is only fair that people have a say in what rules they would be regulated by. Otherwise, it would lead to deep dissatisfaction amongst the people. Thank you, Adrian, for that comment. Mihir has something to say. Yes, Mihir.
Hi. I think in terms of whether it was made democratically, we could see both in India and US, there was a sense of like formal democracy, because in the US, there were delegates sent by the states who were representing the states. And in India, there were elections, indirect elections from the provinces to the assembly and things like that. So formally, there was that sort of democracy. But if you do go deeper into it, you can see ways in which they may not have been democratic. For example, in the US, the kind of people who could even be considered as delegates were only white and were from, the property owning class. And it was pretty similar in India, where I think only 10% or so were allowed to vote in the elections that led to the provinces that then voted for the assembly. So the representatives themselves did not come with the backing of the entire country. But one process in India that I think someone earlier had mentioned, which did help, was the publication of the constitution to the public and then getting feedback and things like that. So those kinds of processes, I think, did make it more democratic, and the attempts of the people in the assembly to keep it democratic.
Thank you, Mihir. Thank you. Anyone who wants to respond to Mihir, add to his points? So what Mihir has essentially spoken about is the representative credentials of both the constitution-making bodies. What he feels that maybe in the formal sense, there was a democracy because they were representatives from the 13 colonies in the US, and they were representatives from the various British provinces and princely states in India. However, when it came to who these representatives itself were, there are questions of whether they were truly representatives of the masses of both countries. And he did highlight one process. So it's not just about who made the constitution, but how these constitutions were made. So Mihir actually highlighted one of the processes adopted in the Indian system, where they presented the draft constitution to the public and asked for opinions. So that is one process that we adopted to sort of ensure that there is some level of democratic participation in the constitution making process. I see two new messages.
Yeah, and maybe I can take that.
Yeah, sure.
So we actually have two differing comments. One, I think, by Puri Kalyani, who says that the decision-making process was democratic enough in the US and in India, as they got opinions from people coming from different backgrounds or colonies, which again, I believe is the point on representation and how it took into account all sorts of communities. Ghanavi says that comparatively, I think the Indian constitution was much more democratically drafted than the US constitution. As stated earlier, the US constitution was drafted by aristocratic white men. It took very long in the US to give women and Black people the same footing as white men. But the Indian Constituent Assembly had women and people from most religions and castes to represent their community's interests. To this, I'd maybe pose another question, which is, do you think the representation of women and other communities, maybe even scheduled castes and tribes, was in fact enough in the Indian Constituent Assembly?
Just to sort of add to that, just to give you facts, out of the 300 odd members of the Constituent Assembly, only 15 of them were women in India. And we had no woman member from the scheduled tribes community. We had one woman member from the scheduled caste community, Dakshayani Velayudan. So do you still feel that the Constituent Assembly was actually representative of various constituencies?
Yeah, Walter, I see your hand raised. Maybe you can go.
All right. I think I would respond to this saying both US and India. My answer to the first question would be yes, they were in the time at that point of time, whatever the conception of democracy was, and when they were going through that regime change, they did what they could. And in the sense of the democracy as it was perceived then, it was done, and it was done well, is what I would say. And why I stay on to this point is because they didn't make a rigid constitution. The people who drafted the constitution did not make something that's going to be immutable. It was open to change. It did allow eventually minorities, women, Black people, all of them to come in. The very same constitutional design was what allowed them to come in and assert their own liberties and rights. And secondly, one distinction probably which we can see from the US and India is, I think at the time of US, I'm guessing, this is a wild guess, but it's an educated guess as well, that most of the people there were educated. The education levels were different and they had one common language uniting them. But the same was not in it was not the same in India, where people had to have that affirmative provisions for them to get to that level of education where they can take decisions on the same level as the other educated people who are there. So with that being said, I wouldn't say that it was a mistake that there were not enough women or not enough women from the more intersectioned minorities. I would say it would have happened if, I think it was the process eventually happened. Today we are having this conversation just 75 years after our independence. So I think that's how I would answer it. I wouldn't say it's a mistake. Probably in today's standards, when we say that, now that we know what we have, right now this session is moderated by wonderful women like both of you. So having that in mind, like we can see the education level, we can see the changes in society. And then from today's standards, when we look back and say, oh, if it were the same situation like this, where women were educated, but they were systematically excluded, then it was a problem, but it wasn't. That's what I would say. Yeah, sorry for that monologue.
Thank you, Walter. So what I assume Walter is trying to say is we also have to look at it in terms of the context, in the historical context in which these two constitutions were drafted, and in that, look at the merits of how representative these two constitution-making bodies were. I think Asha has her hand raised. Asha, would you like to go ahead?
Thank you. Am I audible?
Yes, we can hear you, Asha.
Just to respond, continue on the same tangent as Walter's point about everyone having sort of, when compared to the US and India, when we see the levels of education, I think even in the process of publishing that sort of draft constitution and leaving it open to the public also has a sort of varied reaction, given that when you see who can essentially respond to that sort of draft constitution and make those kind of suggestions, also sort of echoes that you have to be at a certain level of education and at least that amount of knowledge to be able to respond and sort of see who has to be represented and not, so that you can sort of decide in the future who it will represent and who not to. And I think when you talk about echoing the sentiments, or rather the thoughts and processes of who essentially the constitution is going to govern, we're sort of making sure it governs the people, and to echo all of their sentiments is obviously not a possibility, and I don't think it was a possibility back then when it was being drafted either. But I think compared to the US Constitution, the Indian Constitution at least had a better footing, at least in some concepts, in some respects. I think when you talk about things like representation, especially some examples like when we talk about inequality, for example, I think we're at a better footing, but I still think, regardless of the fact, despite having done everything at the time, I don't think it was enough comparative if you talk about it in today's time, but at least that's what I think.
Thank you. Thank you so much, Arsha. Actually, I think we have some comments in the chat box that I'm just going to read out. Then we can take further comments. First, Suvita said, the government power is derived from the people and it is democratic because the people govern themselves. This is followed by Ishita's comment, which says, India is a country that is built on the foundation of a vibrant culture. Satisfying people of all ethnicities was given priority. However, provisions for one led to dissatisfaction amongst the others. So she actually has a question. Is it tough to reach a consensus in such diversity? And does the life of a democratic nation eventually come under threat, seeing the extremities in the country today? So if any of you want to answer that question, I can repeat that if required. What Ishita is asking is it tough to reach a consensus in such diversity? And does the life of a democratic nation eventually come under threat, seeing the extremities in the country today? Would any of you like to answer that? Aditi has her hand raised. Aditi, please go ahead.
Ma'am, I'd like to answer the first part of the question, which says that is it tough to reach a consensus? I think, yes, it's extremely tough. I'd like to take the point of language in India, because that's the most, that's something which we can see where there are opposing arguments, and all the arguments are rooted not only in the lived experience of people, but also a lot of their customs, a lot of their identities is attached to their language. So, so what I'm trying to say is that reaching a consensus, that too in such a short period of time, that is 2 years of time, and coming with a document like that in the Indian context, I think I would say it was an achievement. And to add to the earlier discussion regarding the inclusivity of people in the constituent making process, yes, it wasn't enough. But having said that, I think that is the case even now. For instance, we haven't had any women Chief Justice of India. We do have our hopes with one justice right now, but we don't know. So that's there. We haven't had any scheduled tribe person as a Chief Justice of India. So in the judiciary, which is supposed to be the most representative of people, the most accessible, even in that sector of the state, we don't see representation. So how can we expect it to be there in any aspect? So at that point, having 15, I think, was better than what the state we are in right now.
Thank you, Aditi, for that.
Just sorry, before we call on Walter, in relation to that, we have two comments, one by Hima and the other by Ajita. Hima says that she thinks that the representation in Constituent Assembly could have been more inclusive, but of course, again, considering the social stage at that point, she thinks that an election for the members of the Constituent Assembly would have been hard to set up. While Ajita, on the other hand, says that only 15 women were chosen to represent the female gender in a once matriarchal society where goddesses are still worshipped. Even though we preached equality, this alone demonstrates how male-oriented and patriarchal our culture was. So Ajita doesn't think that our constitution was in fact drafted democratically.
Actually, adding to Ajita's point, I think someone else also commented that the Indian constitution was definitely, I think this is Dhanvi, was not drafted democratically enough. But when compared to the US Constitution, it was at a better position. The universal adult franchise, for example, allowed everyone to vote as compared to the US, where Black people weren't even treated as human beings. Again, we will also have to keep in mind the eras which both these constitutions were drafted in. And just one more quick point by, just this 1 second, by Julie, I think, where she says, even though Indian constitution gives importance to equality and democracy, still ST were not, scheduled tribes were not given equal opportunities in several situations. Thank you for that comment. I see 2 hands raised. I think I'm gonna give Pratibha the floor first, and then we can give it to Walter. Pratibha, go ahead.
Yes, ma'am. So I completely don't agree to the views which have been brought up regarding the democratic nature of Indian constitution making, because as I stated earlier, even it's only when we look at the Constituent Assembly and its composition, prima facie, we can say that maybe the procedure was not democratic. But even if we look into the historical context, as stated by my fellow speakers, or the situation in which we were earlier, we see that Constituent Assembly was there, but it took into consideration opinions and suggestions from everyone. So as I stated earlier, after the draft constitution was made, it was published and people were asked to give their opinions. So I feel that is like the most democratic way in which any legislation can be enacted. Even if we see the current procedure, we have the legislatures and they come up, they don't even debate for more than 15-20 minutes and they just pass the legislations. This constitution making took around 2 years, and in that they took into consideration opinion of all the individuals. They gave at least one chance to all the Indian citizenry to present their viewpoints regarding that constitution. So we don't know when that draft constitution was published, who all came up and gave their opinions. Maybe some women from scheduled tribes also came up, or some other people from different communities came up and gave their suggestions. So we don't have record of all those things. But the fact that it was published and people were asked to give their suggestions and those suggestions were deliberated upon for 3-4 days shows the fact that indeed the procedure was democratic.
Thank you, Pratibha. Walter, if you could make your point quickly, because I think we're running short of time. So
Yes, ma'am. Yeah, just one line I wanted to add to all the speakers who had spoken before me. In addition to satisfying all the people, we often, the dialogue often just goes that the general masses or certain sections of the community were excluded and all. I think, having that in mind, one of my professor Vishnu Prasad sir, he also taught us this in our comparative classes, that when you're crafting constitution, a lot of forces come together to get it happen. On paper, we just see states coming or just few members coming, but when you take a larger picture, it's mostly like the people who benefited from the previous regime and now are moving to the new regime. How will they react to it? The elites, so to speak, and then the military, and then a few other people like this, sections like this. All of them have to be taken into account, and necessarily, for a successful and stable constitution to persist, the elites from the previous regime ought to have been satisfied, that the new regime will not completely erode whatever that they had. They will not, completely be taken off, they won't be caught by surprise. So this factor is very powerful, and often this kind of influences constitutions in different ways. And I think that's something we have to look at. Best way to analyze it, we can't go back in history to see either US or in India, but today, whenever we see a country changing from an autocracy to democracy, plenty of them coming in Eastern Europe and Africa, you look at that, you will have an idea on what forces are at play, and given today's technology, how things can change, how things cannot change. So yeah, I just wanted to mention that.
thank you, Walter. So I think what Walter was just trying to say is looking at also political and institutional compromises that need to be considered while making laws, not just laws, also the constitution. So there are some comments in the chat box which we will respond to on the chat itself, because we're running slightly short of time. So we'll have to move to the second part of this session. Before that, to quickly just summarize what the points we had in mind when we asked these, the second question, the empirical question is, and most of them have been brought out, is one, representation itself, who were the constituencies that were represented in both the constitution-making bodies. 2, how were they elected, which was also discussed by Nihil about indirect election and just sending delegates in the US context, indirect elections in the Indian context. And then the third aspect was the processes that were adopted in the 2 cases. And we discussed some of them, which was the processes adopted in the Indian context, but one that we didn't discuss, which is the 4th point that I was coming to, is the ratification process adopted in the US, which was after the Constitution came into being. They published essays to convince people to ratify the Constitution. So states had a say in the ratification process even after the Constitution was adopted at the Philadelphia Convention. So with this, I think we will move to the second part of the session, which Kalyani will be anchoring.
Thanks, Meenakshi. I will start once you share the slides. Okay, now that we've had a brief idea as to how the constitutional founding process was in the 2 countries, we thought it would be interesting to see the debates and what the framers actually thought about the doctrine of due process of law, and how they sort of thought about it, debated it, or even felt about during the framing process itself. And to start with, we'll start with India, and we look at the Constituent Assembly debates around due process of law or procedure established by law. And this was largely around the 6th of December, 1948. In fact, was on the 6th of December, 1948. We're just going to highlight very quickly the various viewpoints that members had during the Constituent Assembly debates. So Karimuddin strongly felt that if the words according to the procedure established by law are enacted, there will be a great injustice to the law courts in the country, because as soon as a procedure according to the law was complied with by a court, then there's an end of duties of the court itself. And if the court is satisfied that the procedure is complied with, then judges can't interfere with any law that might have been unjust or in fact immoral. The clause, he stated as it stands, could do great mischief in the country. And he thought it was necessary to guarantee to individuals inalienable rights in such a way that the political parties that came into power cannot extend their jurisdiction in curtailing and invading the fundamental rights that were in fact laid down in the Constitution. Mehboob Ali Beg Bahadur stated that he also agreed that he probably preferred due process of law over procedure established by law. And he states that the reason we exchanged without due process of law with except according to procedure established by law was that we took it from the Japanese Constitution. So in the Article 31 of the Japanese Constitution, in fact, states is a similar provision to that of India, and it actually says uses procedure established by law instead of due process of law. So here he says that, of course, it is true that the Japanese Constitution reads like this, but if there are other articles that find place in the Japanese Constitution which completely safeguard the personal liberty of a citizen. Our draft constitution, however, has conveniently omitted those provisions that provide the liberty to citizens and only picked up this one particular line, which Bahadur felt was not sufficient. Chiman Lal Shah brought in the American Constitution and stated that the words due process of law was actually used in 1791. This is by way of amendment. We will get to that in a bit. And he stated that the phrase meant a guarantee of both fair trial as well as in procedure as well as in substance to the citizens of the country. The procedure, he felt, should be in accordance with law and should be appealable to the civilized conscience of the community. He states that it also ensures using due process also ensures fair trial in substance, which is to say substantive law itself should be just and appealable to, again, the civilized conscience of the community. We'll now move on to Aladi Krishnaswamy Iyer, who in fact had somewhat of a different take. He believed that we need to stick to the words procedure established by law and not due process. He felt that in the development of, he also sort of talks about the American Constitution and the working of due process in America itself. And he felt that the development of the doctrine of due process in United States Supreme Court was not adopted, it had not adopted a consistent view. And all the views that the Supreme Court had were almost conflicting and ununiform. So the drafting committee suggested procedure established by law instead of due process of law, maybe because they were guilty and of being apprehensive of judicial whims and fancies in the molding of law, and so stayed away from using due process of law. So overall, he wasn't willing to change from the idea of procedure established by law to due process of law. Ambedkar takes a middle path of sorts. He doesn't say whether we should stick to due process or procedure established by law. One view he states is that the legislature may be trusted not to make any law which would abrogate the fundamental rights of the citizens, and that there's no danger arising from introducing due process of law. However, another view, on the other hand, he states, is that it's not possible to trust the legislature because the legislature is likely to make mistakes. They can be led away by passion, prejudice, other considerations, and then they may make a law that abrogates the fundamental rights that are guaranteed to the citizens. So he says that we're placed in a very difficult situation, and there are two positions that can be then taken. One is to give the judiciary the authority to sit in judgment over the will of the legislature and to question the law made by the legislature on the ground that is not good law in consonance with fundamental principles. And the second is that the legislature ought to be trusted not to make bad laws. And he sort of concludes by stating that it's very difficult to come to a definite conclusions. There are dangers on both sides. And so he wants to say nothing. So he says, I therefore would say nothing, and I want to leave it to the House, the rest of the members, to decide what way it likes and which would be better for the draft Constitution of India. This is to give you an idea as to exactly what happened during the assembly debates. Now we will move to the US point of view, where I will talk about a letter written by Hamilton. So Hamilton in 1783, in multiple private letters, criticized the way in which British loyalists, who were supporters of British during the American Revolution, were treated in New York State. In this particular letter, he criticizes a proposed law in the state of New York, and the New York legislature, which met in 1973, passed several anti-loyalist laws. Among them was one particular one, which is titled an act declaratory of alienism of persons therein described. And this act disenfranchised and punished whole classes of citizens by general descriptions without trial and conviction of offenses. So this alien bill did not become law because it was vetoed by the Council of Revision, whose objections were presented to the legislative session a year later in 1984. But this is the particular law that Hamilton's actually criticizing in his letter. He states that it is in this present moment, we see that the most industrious efforts to violate the constitution of the state, to trample upon the rights of the subject, to infringe the most solemn obligations of treaty, while dispassionate and upright men almost totally neglect means of counteracting these dangerous attempts in relation to the act itself. He goes on to state that the 13th article of the Constitution, this was before the amendments, declares that no member of the state shall be disenfranchised or defrauded of any of the rights or privileges sacred to the subjects of his state by the Constitution, unless by the law of land or by the judgment of his peers. If he believes that the best commentators of law would say that unless by the law of land or judgment of his peers would actually mean due process of law, which is by indictment or presentment of good and lawful men. So this kind of doctrine of disqualification, he refers to the act, of course, disenfranchisement and banishments by acts of the legislature will have dangerous consequences. If the legislature can disenfranchise any number of citizens at pleasure by general descriptions, it will soon confine all its votes to a small number of participants and establish aristocracy or oligarchy. If the legislature, again, may banish at their discretion without hearing or trial, no man is ever safe. And the name of liberty applied to such a government would be a mockery of common sense, is what he argues. He then also draws clauses from the Magna Carta itself to state that men cannot be imprisoned except by law or lawful judgments by their peers. He then goes on to sort of talk about the meaning of the word liberty and how it has been contested. He says that its true sense must be the enjoyment of common privileges of subjects under the same government. There's no middle line of just construction between this sense and mere exemption from personal imprisonment, such as the act. He also thought that nothing could be more ridiculous than the idea of expelling a few from the city and neighborhood. Well, there are other people who would take part in government procedures and acts of the government who will never expect to be objects of such exclusion. So he says that the act, in a sense, confirmed that many in their enmity and prejudices against the state sort of indulge in enmity and prejudices against a few members of the society. With this, he sort of course, this is a very brief summary of what he says in his letter, but he sort of criticizes the Alien Act and argues for due process. With this, I'll just quickly tell you what the due process laws are as of now in US and India. So in 1789, Madison introduced the Due Process Clause to the American Constitution. It was ratified in 1791 and states that no person shall be deprived of life, liberty, or property without due process of law. This was the amendment that was brought to the American Constitution, which is the Fifth Amendment. Now, the 14th Amendment in the year 1868 declares that nor shall any state deprive any person of life, liberty, or property without due process of law. So both the center and the state cannot deprive a person of their liberty without due process of law. In India, Maneka Gandhi versus Union of India case held that procedure established by law was within the meaning of Article 21 must be right and just and fair and not arbitrary, fanciful, or oppressive. Which in a sense means that procedure established by law as in our constitution has almost acquired the same significance as due process of law clause that is in America. So what I will now do is maybe pose the activity question. So once we take that into account, once everybody goes through that, we can then see if there are any questions, because I believe a lot of the answers will come up during our discussions itself. However, if there's anything particular, please feel free to ask me or Meenakshi, that we'll be more than happy to answer. I'm just going to read out the activity. A new law revoking special privileges accorded to Community X is going to be proposed in the Union Parliament. Community X is in majority in the state of A. Anticipating unrest in state of A, before making the announcement of a new law, the government, under a special law, detained several political leaders, imposed broad restrictions on freedom of movement, and banned public meetings. It also shut down the internet, phone services, and educational institutions. The law was introduced, and a year later, most of these restrictions still continue. How would Hamilton and Aladi Krishnaswamy Iyer, on the other hand, respond to such a situation? So what we think we can do is possibly divide all of you into maybe 2 or 4 groups. And group 1 could speak about what Hamilton would think of a situation like this and the restrictions on liberty, while the other will then respond from the viewpoint of Aladi Krishnaswamy Iyer. If anyone has any questions as of now, please feel free to ask us questions. We will give you maybe 10 to 15 minutes for discussion, after which we would prefer if each group picks maybe 2 people who will initially highlight the viewpoint of their group, and then it will be open to discussion for all.
Please feel free to take a screenshot of the screen as is now, because once you go into the breakout rooms, you will not have access to the hypothetical. Okay, maybe we can
put them into breakout rooms. So breakout room 1 could tell us what Hamilton would think of a situation like this, while breakout room number 2 could tell us what Alari Krishnaswamy Iyer would think of a situation like this. Meenakshi will split you into breakout rooms and we will convene in 10 minutes. Feel free to put any questions that you have on the chat. We will try to respond to all of them, even through the discussions.
Yeah, sure. So I'll be speaking on behalf of Group 1, partly because we couldn't democratically decide who to speak because the timer just kicked us out. But I would thank everyone from Group 1. Many of them were active, some of them were listening, but they also contributed in a way for this discussion. So I've just noted down the points that everyone did. In fact, I didn't have any points myself. I'm just going to repeat what they said. So first thing that we noticed that the situation here is kind of where the government wants to do something in favor of the people that voted it to power, let's say the majority. And to this, it doesn't want any sort of dissent. So it kind of proposes a situation where similar to what we saw, what we perceived as Kashmir. In Kashmir, kind of the civil liberties kind of went off the same way. What it had, the effect that this had was an indirect, not direct, but indirectly, you're just preventing anything from happening from the first place before even it happens. So that was the first point of difference. So this is the situation that this is how we perceive the situation. So now if Hamilton were here, what would he do? So we had one person relying that Hamilton would rely on the 13th article, 13th article or 13th amendment, I'm not sure, which brings in the due process clause where no one shall be, disenfranchised or disengaged as a citizen unless there is the law of the land or the judgment of his peers. And furthermore, we had points that said Hamilton would rely on the natural rights that inhered in a person. So, which means that a person or a citizen who's there, irrespective of his position or political leanings or his thoughts and beliefs, he still has natural rights. He has his liberty. He has to be, and by the extension, he has to be treated by the principles of natural justice. That's how the law ought to treat him. And so he kind of tries to define, he would probably define the law differently, but we had a confusion as to, what actually Hamilton meant by the law. We can understand now by induction that Hamilton would have meant a due process because he's qualified it in his paper throughout. But there was a doubt that does Hamilton refer to if democratically following all the procedures or everything, and the government did this by a lawful process, would it still be a law of the land in his terms? So that was a doubt. But despite that, I think what Hamilton would essentially say is no person is going to be, if prior to committing an offense, their freedoms, their inherent rights should not be curtailed unless it is the law of the land or it is gone through that specific process. So yeah, that's all we could get. I mean, it just seems like a repetition, but yeah.
Thank you, Walter. So from what I understand, Group 1 believes that if Hamilton was posed with such a situation, he would say that as long as the curtailments were within the law of the land, it would be okay, but otherwise it wouldn't. Is that correct? Yeah. Thank you.
It was a doubt. It was like we were not settled on it.
Okay, fair enough. Maybe we can move to Group 2 and then open it up to discussion so we get better clarity on this point.
Am I audible?
Yes. Nilavan, sorry, just one thing. I think somebody from Group 1 has their hand raised. Maybe we can let them speak and then move to Group 2 if that's okay.
Yeah, sure.
Thank you. Yes, Pratibha.
So from Group 1, we initially had this perception that Hamilton in his paper or his general idea relied on the two principles, first of the natural justice and the second was the principle of law and liberty. So if we go by these two principles and the analysis which he has done, we initially came to the point that in this situation, Hamilton will criticize the steps which are taken by the government because it's curtailing the liberties of the people and their other rights such as with respect to education or free movement. So by that logic, Hamilton will criticize. But then then in the second part, when we refer to Article 13 on which Hamilton has relied says that one cannot be defrauded of any rights or privileges, but unless by the law of the land. So when we looked at these terms, that is unless by the law of the land, this confusion arose as to whether are we moving towards the due procedure of law from the due process, because initially it looked like due process, but when we see by the law of the land. So in this situation also a law only has been introduced, and a law only is infringing all these liberties. So if you go by the terms law of the land, is this law valid enough? Was the doubt we had.
Understood. And I think maybe I could just quickly reply to that. He actually read law of the land as being due process. So in that sense, your initial point about how curtailment of such rights would be against due process would be correct in Hamilton's view. Nilavan, you can maybe tell us about what Break Room 2 thought about Alladi Krishnaswamy Iyer's view.
Yeah. So I'll start with where Alladi Krishnaswamy Iyer stands with regard to the due process of law. So to his opinion and knowledge, he believes that the due process itself, as interpreted by the English courts, connoted merely to the course of legal proceedings, and it attributed importance to the rules and forms established for the protection of rights and the fair trial in the courts of justice. To this regard, Alladi Krishnaswamy Iyer believes that this is proper and appropriate in some other countries and states where the Democrats believe that they might have a greater faith in the judiciary rather than the executive and the legislature. And he also believes that he would rather attribute importance to the gentlemen sitting, and I quote, gentlemen sitting in the legislature and the executive, rather than the 3 gentlemen or 5 gentlemen sitting in a court of law and stating what exactly is due process according to them in a case-by-case basis, which would only in turn cause inconsistencies. And he also states that I trust the House will take into account the various aspects of this question, the future progress of India, the well-being and the security of the states, the necessity of maintaining a minimum of liberty, the need for coordinating social control and personal liberty before coming to a decision. So we can understand that Alladi Krishnaswamy Iyer belongs to the positive school of thought, wherein the actions of the legislature and the executive would be the logical one and would be the appropriate one, and the judiciary did not necessarily have a place to exactly ascertain what it was wrong or not, because these members of the legislature and the executive were representing the political will of the people and were the proper part of the democratic process rather than the judicial assent. So with regard to the question posed as to where Alladi Krishnaswamy Iyer would stand with the new law introduced, he would believe that the law introduced by the legislature was the right one, and the actions taken by the executive in furtherance of making any such bans on with regard to the internet accessibility would be appropriate, as he believes that the legislature knows exactly to his knowledge better than the judiciary. Thank you.
Thank you, Nilavan. Thank you for, I believe what you meant was that Alladi Krishnaswamy Iyer would in fact say that the law that prevents the citizens of the state to take part in basic activities which is actually given to them through personal liberty laws and fundamental rights would be valid because a law was passed by the land, and he did not actually advocate for due process because he thought that the judiciary should not be given that power, especially because of the inconsistencies in law surrounding due process that you see in the American Supreme Court. Thank you. Is there anyone else from Group 2 who would like to share their viewpoints, or should we open the floor for discussion?
I can just add 2-3 points on behalf of others, which others had raised in Group 2. One was Iyer's position in due process actually changed someone in our group had mentioned after a meeting with Justice Frankfurter, and he believed that the reason why he changed his mind was he believed that due process, when it gives power to the judiciary, it may impede social measures taken, for example, the abolition of the zamindari system and things like that. And another point which was also raised was, as Nilavan also mentioned, he trusted the legislature to have good judgment about whether passing this law would lead to, in this scenario, would lead to any sort of social unrest. And that trust of judgment would mean that the law was valid.
Thanks, Mihir. Is there anyone else who would like to comment on either viewpoints now? The floor is open for anyone and everyone to put their points forward, because I did see that there were a lot of important points raised in the breakout rooms, in the chats. Please feel free to add your points to either the chat or speak up, because that would be extremely helpful in this engagement.
I think Ghanavi has said something. She said, I think Hamilton considered only laws that were just as the appropriate law of the land. That is what I understood by his conflation of the ideas of the law of the land and due process of law. This can also be inferred from his statement that people in power should not abuse their authority and must govern well. That's absolutely, actually, that's a good way to think about how Hamilton views it, considering he is actually not accepting the New York law, a law that is being passed, which could be considered law of the land. He is actually challenging that itself as being an unjust law and therefore not following the due process of law.
Okay, I think maybe we could conclude this session because we have actually run out of time. I thank all the participants for raising important points on both sides. It sort of highlighted why certain framers thought due process was actually the better way out, and some of them did not agree that due process should be followed, and that you needed to put this sort of trust in the legislature to be able to control law and order of the state. With that, I think we can move to the next part of the session, which is the speaker remarks. Meenakshi, do you want to introduce our speaker?
We have with us Dr. Amal Sethi, a fellow at the Faculty of Law, University of Hamburg, where he researches and teaches on comparative constitutional studies with an emphasis on courts, constitutions, and democracy. He's currently undertaking a multi-year and multi-jurisdictional project funded by the Hamburg Research Academy on the design of constitutional courts and how it matters. Amal's other past and present professional affiliations include the University of Pennsylvania, Harvard University, the University of Liverpool, the Legal Priorities Project, and the National Law School of India University. Thank you, Dr. Sethi, for joining us today. The floor is yours.
Thank you. Am I audible?
Yes, we can hear you.
Okay. So, I was hanging around here, so I saw the class is very participative. So what I'll try to do is limit my comments to perhaps less than 10 minutes so that, you all can ask questions. We all could engage in a little debate. So what I'll try to today focus on is one thing that's unique about, and I'll start with this caveat. I'm not a great fan of comparing India and America because I think they're just two very separate, countries, very separate contexts. And I think they're just better comparisons. One of the things about, comparative law is sometimes, you compare things that should be compared. And I generally find, a lot of India-America comparisons kind of, unnecessary. And I think it's, better if you do other comparisons, such as like if you're doing with, it's generally a more tendency in India to do that. We're too obsessed with comparing with the US, UK, but I'll leave it there. I won't, go on a tirade about that. But I think there's one place where it's really good to compare these two constitutions. And that's the endurance of these constitutions. Maybe perhaps a lot of you know, maybe you don't know, but there's one very unique thing about constitutions that have been made since the late 1700s, when constitutions, especially the kind we associate constitutions with, have started being drafted. And that is, they only last 19 years on average. So if you look at that, the American Constitution has lasted around it's going to last about 250 years. Doesn't seem like it's going to die soon. The Indian Constitution is, has lasted 3/4 of a century, and these are very, very high endurance rates for constitutions. Now, it's a different thing whether constitutions should endure so much. That's a very big philosophical debate, and people still don't have an answers about it. Now, I won't really go into first the studies that talk about why constitutions endure, and I'll kind of let you all decipher if you all can make those things out. Perhaps I'll conclude with some of the studies that talk about why constitutions endure, but I'll give very brief more things about both India and America about why they endure. Now, like I mentioned, most constitutions, they last for 19 years. So why do they die? Very simply, and again, really simplifying it, you can put them down to two reasons. One, pretty much most people, most power holders in a country reject that constitution. They want a new constitution. That's the simplest reason where constitutions get, die. The second is when a constitution can't contain disputes or political disputes within the realm of the constitutional politics. And that leads to kind of chaos, violence, anarchy, etc. A great example would just be what's happening in Afghanistan. Everything happened through conflict outside the legal system. And you're right now left in a kind of situation where there's no constitution, and perhaps the Taliban is going to put together a new constitution. So those are kind of the situations when new constitutions are made. Now, let's start with India first. And like I said, I was around, so I saw some of the discussions. One thing you all discussed was that the Indian Constitution, when it was drafted, the Constituent Assembly, it had certain elements of, it wasn't the most inclusive body. And especially at that time, if you look at the major groups in the society, it wasn't very representative of backward castes and classes, if we want to categorize them. It wasn't very representative of women. It wasn't very representative of, it didn't have members of the Muslim League, who still were kind of like a powerful source back then, at least. It also kind of, in some very small way, sidelined the Hindu right. It also sidelined communist socialists who still were voices in the society. But there was one thing unique about, and it was completely, the other thing was it was completely dominated by the Congress party. But there was one thing unique about the Congress party, that it was internally quite diverse. And that internal diversity, at least again, the other thing to know about constitution making is that most constitutions are made under very, very unilateral circumstances. So when we look at that, the Constitutional Assembly, okay, wasn't perfect. It was decently diverse, and that led to some accommodation. So that was one thing that was going around for, it did have at least strong voices from, let's say, communities and groups that mattered in terms of causing the death of the Constitution. There were very few groups that were excluded from the making, or whose voice weren't represented, who could have, in the initial stages of the Constitution, caused the Constitution to die. So that's one thing. The second thing is that the Indian Constitution is really long and it's very detailed. And there were some details which were put very explicitly. For example, Ambedkar was very, I would say, quite, he was quite firm that we need to clearly spell out, things regarding reservation, regarding minority rights, etc. There were also several other things that were explicitly spelled out in the Constitution. And the third is the amendment procedure. Now, India has a very mixed amendment procedure. Some things can be amended as an ordinary legislation. Some things require a larger vote in both the houses of the parliament, and some things require approval of the states. Perhaps, I once had this discussion in another place, and we were comparing amendment procedures across the world, and most people didn't think India had a very flexible amendment procedure. But now here again, it's important to know that some dynamics played out where, things that a government wanted to do and really wanted to do, they could get it done by constitutional amendments. And this has happened throughout history. And it's a lot to do with certain political as well as these design factors. And now, when it comes to design factors, a lot of early amendments, which were very essential, they were, they were able to be passed very simply because India was a dominant party country. The Congress had a lot of say, and when there was good internal agreement within the Congress, yes, there were political battles behind and there were things to do, but things like eliminating the right to property, eliminating zamindari, reorganization of states, they were easy to do. And India being a dominant party system played a very important role in that happening. Over time, what's happened is now the Indian Constitution, and I think it would be very hard to make that claim that it's a constitution which, if any group in the country reads, they would like completely hate it. Everyone takes away a little bit of hope from it. Not a lot, but a little bit. And that's also got a lot to do with just how much the constitution contains. So, and a lot has changed due to amendments, but it's let those groups believing, again, groups that can cause trouble to the constitution's endurance, that there's some hope here. And, another, constitutions actually die when there are these really tense political moments. It's actually not a very, discussed thing or a commonly known thing, but, Indira Gandhi's emergency regime actually did have plans, and she kind of asked some advisors about actually drafting a new constitution. That within the internal Congress was kind of shut out, said that's a stupid idea, we are not going to go ahead with it. But still, Indira Gandhi was able to do a decent amount of authoritarianism simply because the constitution was flexible enough. Countries do go through these moments, and what happens, like, to take a very good example is Venezuela, where when Chavez came into power, he saw a constitution that he couldn't work around with, and he unilaterally went ahead and drafted a constitution. Indira Gandhi got the opportunity that she could do the kind of authoritarianism at least she wanted to do within the constitution. So that was another moment the constitution could die. Generally, a lot of times when authoritarian leaders come in, especially in that era, they drafted new constitutions. So another one of those moments where just the kind of amendability rules we had, Congress being a dominant party, that really helped. And sometimes, when countries recover from authoritarianism, that's another time when constitutions die. The Janata Party, again, because, by that time, people knew that, even people within the Congress, they started knowing that authoritarianism wasn't the kind of emergency moves and the kind of authoritarianism Indira Gandhi pushed. That wasn't the best of things. And so there was good consensus within even the Janata Party to kind of undo some of those changes brought about by the emergency era amendments. So, so these are kind of, some of the reasons you see the Indian Constitution surviving. And even today, we are back to, like a phase where democracy is under strain in India. And a lot of what BJP has been able to do, they've been able to do within the constitution framework. They've not needed to change the constitution. Countries go through moments of stress, and it's those moments of stresses where constitutions get rejected. And in India, in those moments of stresses, it's the fact that people have found ways to work within a very large framework constitution, which allows you to do a lot of things, which provides a lot of detail, and which at no point of time is going to be hated by so many people that you can kind of replace it. Because what happened with a lot of, you all would be aware that Hungary, when Orban came into power, he got a new constitution drafted, and he got it basically on the premise that this is a remnant of the communist era that we need to kind of dismantle. And everyone was on board with it. They didn't care what's the new constitution being drafted. But even when I gave that Indira Gandhi example, people develop that sense, especially elites and people who matter, people who can cause problems for the constitution. They, at any given time, they had that reverence for the constitution that they're like, okay, this is not happening. And I mean, a great thought experiment to think about is if the current government, the top brass, wants to change the constitution, how much buy-in can they get from other power holders in the party? It's a great thought experiment. I don't know the answer, but I assume it's going to be really hard. So that's kind of where, you know, India stands. Now, America has a very different constitution to India. To start with, like you were all discussing earlier in class, it wasn't at all an inclusive drafting process. It was dominated by elite white, really elite, very, very, very elite white men who kind of were pretty much some of the most influential people from their states. They got together in a room and they drafted a constitution. And even within the people who drafted the constitution, there wasn't that much consensus. 16 people voted against it. Rhode Island didn't participate in it. But again, it's important to remember what happened, what was America at that time. America actually didn't come together as India. It more came together as a lot of separate small countries coming together and making a constitution. So the kind of constitution it created, it did kind of bridge the state and center divide. It did bridge the urban and rural divide, because a lot of urban states had a problem that, you know, what would happen if the rural states with more population get a greater say? And that's why, like, electoral college rules, a bicameral legislature, these kind of things helped. But again, this is America is not that simple an example. As you all know, slavery was a big issue back then, and one compromise, and it was right from the days of founding. So one compromise that everyone kind of agreed on, that we're not going to change anything regarding slavery by till 1808. That was about 20 years after the Constitution was drafted. So that kind of made people okay with it, but at least the progressives, they misunderstood that things would change in 20 years. So things didn't change in 20 years, but it allowed the Constitution to last 20 years, which is, again, more than the average age of a Constitution. That was one of the big disagreements. So where does Americans' Constitution stresses come? The first was that the founders of America, they didn't expect that there will be something known as a party system. So that was one thing. It just didn't come to them that, and I mean, this is another very important facet of constitution making. There are things that, you know, sometimes you just don't think too much about. In India, we thought a lot about courts and how they'll protect rights. We didn't think too much about judicial design. It's one of the lesser, and I think that's one of those things, like, say, in India, that's created a problem till today. But there are some other countries where they overthink about judicial design rather than what courts will do. So that's things that you just don't think, or it doesn't come to your mind. And that's another reality of constitution making. So in America, they didn't think political parties would happen. So the first stress came in the 1796 and 1800 elections. The party system came up, and it so happened, as you all, so the one thing about American elections is it's been kind of constant back since the days. So, you know, people you vote for a president, and a president generally stands with the vice president. And generally on the ticket, you write like the same party's vice president. Very few people do that. And I mean, the one thing about America is you can actually go and vote for Brad Pitt, and it will actually show that one vote is counted for Brad Pitt. So what happened was that people didn't kind of like the vice president candidate, and they voted for a vice president candidate from another party. So that was one thing, and that kind of led to a lot of confusion, chaos. The next time what happened in 1800 was when the electoral college's votes were counted, Jefferson and Aaron Burr got the same amount of votes. And that again kind of created a problem. And these are exactly some of those tense political moments when things go out of hand. So Bruce Ackerman kind of says that one of the reasons these things worked out was just good luck, nothing else. So that happened. It just happened that, you know, there were enough good statesmen around who kind of, you know, made sure things don't go out of control, and then just things happen. But historically, there aren't very good reasons to explain how a constitutional crisis didn't happen. But this wasn't still the major of the things that could have caused the demise of the Constitution. That was the Civil War, because slavery was still an issue. Also, now again, the American Constitution actually is very hard to amend. It it requires 3/4 majority from states. And for any of you who even see a little bit of news, you all know how divided states are. And the thing is, the divisions were different back then, but there were still these kind of divisions. In fact, the entire civil war was fought by one half of the states against another half of the states over slavery. Now, generally, these are again times when constitutions die. There'll be a victor, they'll draft a new constitution, and especially a constitution. And this is very common in, say, when you want to like be progressive. You want to move away from this previous constitution. You don't want anything to do with it. But what happened was that when the North won the civil war against the South, the first thing happened that the people who lost, and they were also power holders, they kind of lost their power. So there was a power vacuum. And people in the North just decided that Reconstruction amendments are good enough to do that. And they just went ahead, and the American Constitution wasn't flexible, but there was a lot of power vacuum, which allowed changes to happen. So that's another thing that happened. America, even, and that period, there was a lot of, for the next 20 years or so, there were a lot of power vacuum. There was quite a lot of active citizenry. So even in the later days, say the amendment that allowed for women enfranchisement was able to pass, but that was not easy. If you look at the kind of movement that required, that was a very, I was once studying this topic years back, and you all know there are a lot of these, again, a lot of bills have been passed in the Indian Parliament to get more representation for women for women lawmakers, etc. But just drawing a comparison from America, the movement for women enfranchisement, that actually was a very big mass movement. So that combined with the power vacuum, that led to another amendment being passed. After that, the constitution has been fairly stable. It's a constitution that doesn't provide too much detail. So what's happened is, with like all the vague provisions, every side tries to put forward its own interpretation. And a lot of people attribute that vagueness to the constitution lasting. Now, in terms of actually sometimes solving major disputes, America has kind of always operated outside the constitution. Their courts have added a lot of detail to the constitution's meaning, especially in practice. And this is one very, again, a difference between India and America. We often talk about the Indian Supreme Court as this hyper-activist court, but and it's been very hyper-activist in periods. But I think the very big question is that a lot of the laws, how much change has it really brought about in terms of what things are happening on ground? Because a lot of times, if you look at all these Keshav Nanda Bharati, Golaknath, that entire wave of decision, they all in some way or another use passive virtues. Things like, they gave the decision via an arbiter, or they use prospective overruling, those kind of things. So they didn't really change the thing that was happening. But the American Constitutional Court has really, it's not been that expressive in giving decisions, but it's been able to add a lot of meaning to the constitution, which has changed very recently. Same-sex marriage. I mean, they kind of did it through by reading it into the constitution, but that could have become a big issue. So the American Supreme Court always in these moments have really helped add clarity to it. And just beyond that, politics has been able to fill a lot of meaning to these things. And it's the way constitution that has helped every side really, even something like the Second Amendment, which there is, no consensus on that country. The beauty of the Second Amendment is everyone can have their own interpretation of it, because it's just so vague. Some people argue that the Second Amendment only allows state militias, which were a thing at that time, to have arms. Some people say that it's for personal protection. Some people say that, I can keep tanks and AK-47s in my house. It's the vagueness in every provision of that constitution pretty much has allowed different sides to come together, agree on it. But over years, what's happened, and this is the important takeaway to take from here, is the American Constitution has lasted so long that it's just become so important a part of the society that now it seems like, it's going to be really hard to do anything, even though the amendment procedure is so hard, and that does lead to, problems, but it's lasted so long that one lesson we can take away is that once a constitution passes through its initial shocks, it kind of lasts. So what I'll open the floor to you, and there's no answer to it, is why do you think constitutions last? And when do they last? From what I said, what could you perhaps add to it?
Thank you, Dr. Sethi. Do students have any responses? You can put them in the chat box, raise your hand, and we'll take that up.
So maybe you could just give them a minute to think through
Okay,
the questions.
sure.
Yeah.
Walter?
Hey,
Yeah.
Walter.
Sorry, I was muted. Hello, Dr. Amal Sethi. Thank you for that. It was fast. Takes me time to still process it, but I kind of got the drift of what you were saying. And I was able to kind of understand it better because I read this book. It was not a legal book by any chance, but it's a book. I think I've also told my professor, Dr. Vishnu Prasad sir, also about this a lot. This book, Why Nations Fail. And most of what you've said, they've kind of simplified it and said it in a political economic context, and said it in a general audience kind of way, where inclusive institutions, one, and rule of law and a strong centralizing political authority. All of this, in having all of a nation or a state which has all of this, it can design a constitution which is going to kind of last. And constitution as a means to have an inclusive nation as such is one way in which I think it can last. But I have a question from based on what you said. Do you, because this is something that came up as you were talking about how the Indian Supreme Court is expressive but kind of gets divorced from the ground realities, whereas United States court kind of acknowledges the ground realities in a less expressive way but more meaningful way. So with that in question, like, do you think that, I mean, how do we, I wouldn't say to you, I would just ask this openly, like, is constitutions the one that kind of direct change in society, or does the society take change and the constitutions adapt to it? Which is the cart and which is the horse?
So I'll answer this by stating this. There's a very good empirical recent book out by two scholars called Adam Versteg and Mila Chilton. It's called How Constitutional Rights Matter. And it kind of builds up on a lot of like similar research, but I'm just citing it because it's the most latest on the topic. Their kind of conclusion is that neither do courts matter, neither do constitutions matter, really. They can be like this small missing piece of a puzzle in the larger scheme of things, but what matters are actually things like interest groups, political parties, mass movements. Those are what bring about change in society. And I think, we've reached a point with research that major change in society, we can always attribute to them. It's even when constitutional courts, you see them kind of very at the forefront of driving change. And that's happened in countries like India, Colombia, South Africa, which have activist courts. The right to food example is one of them. But if you actually look at the backstory of things, it's a lot of, that political parties in power themselves wanted to push these things. So a lot of times those are the factors going in the background. So Chilton Versteg, they have this small part where they kind of say that independent courts don't matter really to constitutional rights. There's this actually very, I said that about America, but Mark touched it, like a very major scholar on this. He actually says that American court was good in adding details to things and kind of placating tensions. But he makes this kind of just a hypothesis. He feels that there's no Supreme Court, America would still be the country it is today. So those are interesting things to think about. Surely, it's very tough to imagine, but I think the best answer I can give you to it is yes, political parties, interest groups, mass movements, they bring about change. Everything else is important and you can't disregard them, but you can't think that they are going to be the drivers of change.
Okay. Thank you, Dr. Sethi.
Do any of you else have questions similar? I would be more than glad to take them.
I just have a comment to follow up on what you said, if that's okay.
Sure.
If anyone else has questions, I can. Yeah. So I think from what you said, this is something that I was working on just a month back. I was looking at transitional democracies or countries that were recently moving from autocracies or failed regimes to democracies. And this is happening at the behest of international institutions. And this was whatever you just said. I think that kind of struck me because there the IOs kind of wanted to build in a formula saying, hey, you should have a constitution. Hey, you should have rule of law. You should have these kind of indicators. And voila, you have a democracy. And that's kind of going to hold up and work just the way that successful democracy so far has gone without even actually the moments being there. And we can see Afghanistan, despite years and years of nation building, funding, and all of that, we still haven't, unless the people themselves decide something, it just doesn't work that way. So I think I've got that clarity from what you said. And this book, which you recommended, I'll definitely pick it up. And I also wanted to mention that Dr. Mark Tushnet has come to our university. He has addressed us on this point. And he is someone who believes in the legislature more. I think he would side with Aladi Krishnasamy Iyer than Alexander Hamilton. I think he quotes this vibrant democracy often in his work, and I think I've read that too. So yes, thank you so much.
The interesting thing about Tushnet is he's one of those very few people who could be classified in America as being part of the hyper left who believes in this. So it's a very important, it's a very fascinating thing to think about, because most people who are political constitutional, especially in America, they are actually on the extreme end of the right spectrum. So it's very interesting to see a person on the other end of the spectrum having that kind of argument. But I see that there's one question, but I want to say one thing about Afghanistan. Back even in 2003, so if the 2003 edition of the Journal of Democracy has a few articles by a person called Reuben Barnett, something Goodson, I'm blanking out. And one thing, a lot of these people, and you can extrapolate it from, say, works by Andrew Arato or David Landau, a lot of them would actually argue that, the biggest mistake was not negotiating with the Taliban and trying to run them out of the country. And people have been saying this since 2003, that if you actually, and actually the thing was, with respect to the Afghanistan process, they just underestimated not only Taliban, but every other non-democratic looking group, that they said, okay, we add these elements and democracy is ready. The thing is, a country has different groups, and you sometimes need to acknowledge that they exist, and sometimes they don't think about democracy the same way. And that's what's happening in Afghanistan. The one reason Taliban has a lot of buy-ins is from actually, say, regional militias, warlords, etc., is people don't like Western democracy that much, or people forget that not Western democracy, people don't like West that much. So initially, if you had more buy-ins, that could have, again, no one knows how these things would play out, but a lot of people even back in 2003 were arguing that this is a big mistake we are doing. But there are two questions. Are the interests of political parties essential for driving change? Would these problems on ground realities otherwise be addressed if not for them? Not always. Sometimes mass movements itself can be, I said they are one of the things that drive change, and they're very important in elite outcomes are very important in how things happen. But if you look at Africa, most dictators get toppled because of mass movements. Yes, they do get toppled because of coups as well, but a lot of times mass movements have actually been very responsible for transitioning. So I said political parties, interest groups, mass movements, they are the kind of things that are more essential to bring about change than say a constitutional court, or say institutional design framework, or the constitution itself, really. Okay, so the other question, not related to your lecture, but sir, what are your thoughts on giving citizens the veto power, like in the Swiss political system? I have no idea what the veto power in the Swiss political system is. I would be more than glad if you could elaborate on them, and I would give my views if I have anything.
What I know, sir, if there is a bill passed by the Constitution, the people can sort of prepare a memorandum as such where they can sign against the bill, and the bill gets rejected. So
Oh, okay. And yes, and that's a feature very common to certain countries. And it's perhaps like, I know we're short of time, but I can perhaps like, use this to kind of build like a larger point and say that in practice, it all sounds fine. But sometimes the question is, I'm like, again, diverging. A great example is Iceland. So Iceland wanted to draft a new constitution, and they kind of public sourced it, crowdsourced it. They had these, you could log in through your Facebook account on this portal and or Gmail or whatever, like however you log into any other website, and you could like leave comments on a constitution. So they crowdsourced this constitution, and then just all the political parties decided that, hey, you know what, we don't like this constitution too much. Let's just not come up with a new constitution. The thing is, these all things sound very good in practice. Sometimes the question is, they in terms of practice, they are more legitimacy building exercises when they work. And often, the problem with some of these, and I'm being a devil's advocate, it's tough. Like, it's tough to answer this. In practice, it does sound like a great idea because it's democracy in action. The problem with some of these is, like I said, one, at the end of the day, it is political elites that are going to take decisions. But the second problem is it's precisely these kind of provisions that, often give rise to and allow legitimizing very majoritarian outcomes. Now, on that note, like, the last two kind of small points I wanted to make is there's this article by a scholar called William Bartlett called The Perils of Popular Constitutional Making. Great article to read. And he kind of makes a case. And even there's another article by David Landau called Constitution Making Gone Wrong. It ties up to what you were all discussing early in the class. And they make like very strong cases for why there shouldn't be public participation in constitution making. I won't really go into the details, and but it's more to do with why, like in more cases than not, you should not like do over public participation. Perhaps little indirect elections or something like those, or like consultancies and all are fine, but like too much hyper public participation can lead to very majoritarian outcomes. That's the argument that makes it's a good thing to think about and just kind of weigh where you feel. But then there's this new book, another, like I'm just throwing some literature because it's such a short class. I'm like more kind of like drawing you towards literature that you all can read. There is one very new book. It's called Remaking Constitutions in Democratic Regimes. It's edited by a person called Gabriel Negreto. And there are two chapters specifically in it, one written by Gabriel Negreto, the other written by a woman called Ana Maria Bejanro. And both of them, they're both empirical studies, and both of them actually say that public participation can help do other things. But if you want to actually promote democracy, the most important thing is that different power holders come to a negotiated bargain. So elite outcomes matter. Public participation can like serve very different purposes. And but yeah, if you want to read about them, read Jennifer Widener, another scholar on this topic. She's got some chapters, she's got some book about and she kind of talks about some other purposes with respect to state building that public participation can serve. But Negreto and Ana Maria Bejanro in their respective chapters, through like one, a case study approach, the other through a large data approach, kind of show that it's when elite compromises happen in a good way, that's when we lead to deepening of democracy. Generally, public participation, etc., they too much can lead to very hyper majoritarian outcomes and not like deepening aspects of at least liberal democracy. But I thought this was my conclusion, but like let me just see the questions and see if like I can give quick answers to them. So not related to constitution, but do you think our profession as future lawyers is future proof? Because I read an article where it was written that all lawyers, they say it was an article by Mom. I actually have no opinion on that. I do not know anything about AI, but just as a very lay person, I see like I think lawyers are smart enough to find like a way to make good use. And one like interesting factor that I'll just throw around is that most people in law school, and this is something you will all realize 10 years after graduating, very few of them stick to law. So most of them actually do different things. Very few actually stick in law firms. Very few actually litigate in court. The number is very, very small, and that's across law schools. So perhaps even that's like at least in India, that's an interesting thing to know. Like my entire friend group from law school, no one does law. Like I had a 6 people friend group. Even I'm like an academician. No other people don't even practice law. Like someone is a fashion designer, 2-3 are in startup scenes. No one does law. Many similar recall mechanisms for elections in US are also used by corporations. For example, Uber on yes, and I mean one of the biggest problems in democracy, and again, a lot of people talk about is the kind of money, the kind of pull like in capitalist societies corporations have over elections. I mean, just consider Facebook today. Facebook doesn't even need to put in money to rig elections. If maybe India and America are 2 big countries to do that, but if there's a mid-sized country and Mark Zuckerberg really hates a political leader in that country, I don't see how it's very hard for him to completely rig that election by just manipulating information. So corporations do have a very heightened, and I think Brazil is a very good case to see, because they had these very open rules where like it just became that rigging elections by corporations became their new CSR, because they kind of had this like workaround where election contributions could be this form of CSR, but then their Supreme Court said that, okay, you can only put this percentage. But before that, Brazilian politics was completely dominated by how the big countries, like who were the people that big countries wanted to play. The downside to that was once that got over, it led to populism in Brazil, and Bolsonaro came in. So another fascinating thing to, think about. But the last one I see is, I think it is the flexibility of the Constitution and its ability to incorporate the possible situations that can arise in future through its broad or maybe vague terms, which helps in Constitutions last. Also in the Indian Constitution, I feel the judiciary has indeed played a vital role in helping the Constitution to last by the way of decision when SC stopped legislator from interfering with the basic structure of the Constitution. So with this, I will like actually conclude. So I said I will not talk about studies that talk about why constitutions endure. There are a lot of them, but I think the one that basically plays a part in all those other studies is a book by Zachary Elkins, Tom Gilsberg, and James Melton. It's called The Endurance of National Constitutions. They examine, it's a little complicated book to read because it's quite a quant heavy book, but they identify 3 criteria that make constitutions last. The first is what Pratibha mentions, that is the flexibility. The second that they talk about is inclusiveness during drafting. And the third that they talk about is specificity. Now, in every case that doesn't apply, but even I would like strongly urge you to read the chapters on India. There's actually a chapter on India and America in the American Constitution. And they talk about how both these countries don't fit very well into these criterias. But when you like really look into it, it worked in very different ways. But if you're designing a constitution that you want it to last, if you think lasting is a good thing, these are factors that go a very long way. So that most research around endurance of constitutions rests on these 3 factors. Now, as far as the last question is concerned, I'm not very sure. I mean, different people have different interpretations. I'm not very sure how much I agree with it. I think the basic structure doctrine and like the decisions around it has been very good for people to keep faith in the institution of the court, to keep faith in democratic processes. But I think the big question to ask is, whenever the government wanted to do anything, bar I would say, the NJAC, was the court really successful in stopping the government from doing that? And the NJAC also, by that time, from what I understand, is that even the BJP government gave up on it because they realized that, there's a better way to rig courts. And we all know how they do that. But they just realized that we actually can find a better way to rig courts without anyone coming to know how like judicial selections are manipulated. So I'm not very sure on that, but I know there's a lot of disagreement on this topic. And I know different people see it with different lenses. This is the lens I see it at, but I know people have written books on why the basic structure doctrine has saved Indian democracy, why Keshav Nanda Bharti was the tipping point. I've not been very convinced with it personally. So I'll kind of, I'll kind of conclude with this. Thank you. And if you have other questions, please feel free to write to me. Would be more than happy to answer any of them.
What we could also do is we could take the questions from the chat boxes and maybe send them over to you for your
That would be,
responses.
yeah, that would also be perfect.
Yeah, we'll do that. Thank you so much,
Okay,
Dr.
welcome.
Sethi. This was a great session. It was very, very engaging session, especially since you, sorry about that, especially since you took us through not just some of the factors that could lead to enduring constitutional documents, which is you highlighted details, flexibility, party dominance, and moreover, maneuvering through stressful times and circumstances. And we also had a great discussion on the roles of institutions and the polity, including corporations, in sort of in nation building, state building, and governance. So thank you so much for that, Dr. Sethi.
Welcome, and thank you for having me. Okay.
Thank you. So with this, we're concluding session 1 on constitutional founding. Because we're slightly running behind time, maybe we'll take a quick 10-minute break before we come to the second session on personal liberty and freedom of choice. So if we could reconvene at 11:55, that would be great. Yeah, thank you. All right. Okay, we'll start with the session. So in this second session, we will be focusing on personal liberty and freedom of choice. Now, both the Indian and US constitutions treasure the concept of liberty, but let's look at how they do it in their own contexts. Once again, I'll just take you through the outline for the session. The session will once again be divided into 2 parts. In part 1, I'm going to take you through the bare provisions in the Constitution and take you through 2 readings that have been shared with you on the evolution of due process in India and the US. This will be followed by a small student discussion. And then we will have part 2 where Kalyani will take us through 2 cases. And this will be followed by a student activity. After the activity, we will have Senior Advocate Jayna Kothari talk to us about liberty and freedom of choice for 20 minutes, and then we will conclude the session. I hope there aren't any questions, so I will proceed with the provisions itself. As mentioned by Kalyani in the earlier presentation, the 5th Amendment, which was introduced as a part of the Bill of Rights, gives us the first sort of due process clause as we understand. So the 5th Amendment, if you read it, would have actually 3 parts. First, which talks about criminal procedure clauses. The second, which actually talks about the due process clause itself. And the third is something known as the takings clause. So although the 5th Amendment due process clause is brief, important parts of Supreme Court's constitutional doctrine rest on this particular provision. And at the most general level, the clause reiterates the principle of rule of law, that the government must act in accordance with legal rules and not contrary to them. A more specific application of this clause is the doctrine called today that we call as procedural due process, which concerns the fairness and lawfulness of decision-making methods used by courts and the executive. Government actors who violate due process, when they frustrate principles of fairness of proceedings, such as say for when a prosecutor fails to disclose evidence to a criminal defendant that suggests that they may be innocent of a crime, or when a judge is biased against a criminal defendant or a party in a civil action. So essentially invoking principles of natural justice. Now, if we go to the 14th Amendment, this was ratified after the end of the Civil War on July 9, 1868. Now, the first sentence of the 14th Amendment granted citizenship to all freed slaves. I haven't included that provision here. But the second sentence contains 3 key provisions. One is the Privileges and Immunities Clause, the Due Process Clause, and the Equal Protection Clause. So as you can see, I will come back to why it is important to look at the 14th Amendment when we're going through the reading, and what is the difference between the 5th and the 14th Amendment. Yeah. So for this, we've actually given a small reading on substantive due process, a history of liberty in the due process clause by William R. Musgrove, who takes us through the sort of judicial history and jurisprudence on how this doctrine has been adopted in constitutional practice in the US. So what is substantive due process? So what William Musgrove says is that under the theory of substantive due process, a court can step in via the 14th Amendment's due process clause and provide substantive protection from government actions that violate an individual's right and liberty. So what this article essentially does is explores how this substantive due process came into being. Now, since its sort of conception, there has been a lot of litigation over exactly what the due process clause means and what rights and protections it affords. So there are three main types of substantive due process cases that emerge. First are the incorporation cases. Second are the economic substantive due process cases. And third are the right to privacy cases. Most of today's substantive due process litigation revolves around the third category, the right to privacy cases. But it is useful to have a basic understanding on the other types of litigation and that have sort of shaped the history of substantive due process in the US. So let's come to the incorporation theory first. And this is where we'll understand the difference between the 5th and the 14th Amendment. Right. So there's been a long debate over what sort of rights and liberties are afforded by the Constitution. So once a right or liberty is recognized, the question then comes to who can ask for this right or liberty and under what circumstances, who enforces this, against whom can this be enforced, etc. So this was the sort of problem that arose with the Bill of Rights itself, which is what had the 5th Amendment. So as mentioned earlier, the Bill of Rights explicitly guarantees many protections and rights to the people of the United States. In fact, the Supreme Court in Barron versus City of Baltimore in 1833 held that the first 8 amendments of the Bill of Rights only protected against actions by the federal government and not actions by the state and local governments. So in order to solve this problem of how to use the rights contained in the first 8 amendments to protect against actions taken by state governments, what the court ultimately decided to do was use the theory of incorporation. So what it does is it uses the due process clause in the 14th Amendment that guarantees that no state shall deprive any person of life, liberty, or property without due process of law. So they sort of incorporate, in this incorporation, what they're essentially doing is integrating the rights of the first 8 amendments into the due process clause of the 14th Amendment, which in turn makes these rights applicable even against the states. So this is easy. So what the incorporation theory essentially does is rights that are enumerated in the Constitution are now being made applicable to state governments through the due process clause in the 14th Amendment. But what about, how does the court grant protection of rights that are not explicitly written in the Constitution? So for that, we'll have to look at the next 2 categories of cases, which is the economic substantive due process and right to privacy cases. So substantive due process in courts, using the theory, using this doctrine as basically to limit regulations on economic activities. So in a typical case, what happened in this era of litigation was that the government would regulate an economic activity and the individual would claim that the government was intruding on his or her property interests under that theory, and this was in violation of the due process clause of the 5th or 14th Amendment. The court would then step in and limit the government's intervention on this activity. So in the most famous case involving the theory of economic substantive due process was in 1905 in the case of Lochner versus State of New York. In Lochner, the court struck down a New York labor statute that prohibited bakery workers from working more than 60 hours per week. Now, the state of New York argued that it was simply using its police powers to protect the health and safety of its citizens. Now, the court rejected this argument and held that the regulation would unduly interfered with the liberty of contract between bakers and their employers. The court derived the economic theory of liberty of contract from the due process clause of the 14th Amendment. Here, there's no liberty of contract provision to be found anywhere, either in the 14th Amendment or in any other part of the Constitution. Nevertheless, the court stated, and I quote, that the right to purchase or to sell labor is a part of the liberty protected by this amendment. Although the court did recognize that a state had the right to interfere with liberty of contract under its police powers to protect the health and safety of its citizens, the court did not believe that it was justified in this particular instance and therefore struck down the New York provision. So courts have subsequently used this doctrine to either strike down or uphold many economic laws. But there was a shift in 1934. In the case of Nebbia versus People of New York, the court upheld a New York law that regulated the minimum and maximum prices of milk. Typically, if we had to go by the previous judgment, the court would have said that this law would have been struck down because it interfered with the liberty of contract that was protected by the substantive due process clause. However, what happened in this particular case is that the court made a sort of departure from this theory and stated, and I quote, "But neither property rights nor contract rights are absolute. The guarantee of due process demands only that the law shall not be unreasonable, arbitrary, or capricious, and that the means selected shall have real and substantial relation to the object sought to be attained. The Constitution does not guarantee the unrestricted privilege to engage in business or to conduct it as one pleases." So with this, many people thought sort of substantive due process has died down because the state has power to regulate it. But with that came the next sort of set of cases known as the right to privacy cases, which even after Nebbia, a key sort of idea of substantive due process remained. It stated that in these cases that it could provide constitutional protection for rights and liberties that were not enumerated in the Constitution. The court recognized sort of implied fundamental rights as being protected by the Constitution, but which are not explicitly stated. So the right to privacy is a broad area of substantive due process. So modern litigation surrounding substantive due process often centers on this right, as I had mentioned earlier. And the underlying idea is that there are certain areas of an individual's private life that the government cannot intrude upon. Even though the right of privacy is not mentioned in the Constitution, it is nevertheless protected by the 14th Amendment's due process clause. In particular, it's protected as an implied fundamental right by the liberty provision in this clause. So the right of privacy is an umbrella term that sort of encompasses various fundamental rights, like, for instance, parental control over the upbringing of their children, procreation, family, and private sexual activity. So the article then takes us through some of these cases. I don't think I'm going to get into those details right now. For the purposes of this session, this is sufficient to understand how the substantive due process doctrine has evolved in the US. Now let's look at how it was adopted in India. So before we go to that, the provision which talks about liberty is Article 21. And it says no person shall be deprived of his life or personal liberty except according to procedure established by law. And we've had a fair share of discussion on why the term procedure established by law was adopted instead of due process. So, so as we sort of discussed in session one, our framers deliberately made that a choice. But courts have nevertheless used the due process doctrine in India. So let's see how courts did that. For that, I'm just going to take you through Manoj Mate's piece on, I think the slide is not visible.
Yeah, don't worry, I'll just put it up.
Yeah, okay. So Manoj Mate's piece in the Berkeley Journal of International Law, where he sort of, these are excerpts, not the entire piece that was shared with you, where he takes us through a series of cases to see how the judiciary has evolved the sort of concept of due process and how it's adopted it in the Indian context. So he starts with Gopalan versus State of Madras, in which the constitutionality of a Preventive Detention Act was challenged. Now, the majority judgment drafted by Justice Khanaya says that, relying on the originalist intent and the text of it itself reads Article 21 in a very narrow format. So they sort of distinguish it from the US counterparts of the 5th and 14th Amendment simply because of the term procedure established by law and due process and the deliberate constitutional choice our framers made. And so they sort of denied the theory of incorporating rights mentioned in other parts of the Constitution, for instance, Article 19, which prohibits restrictions on freedom of movement, into Article 21 in understanding whether procedure established by law is followed. But in the dissenting opinion of Fazal Ali, what he does is interestingly incorporates procedural due process and principles of natural justice in the meaning of the term procedure established by law, and reads in Article 19(1)(d) as a part of Article 21. So essentially what Fazal Ali was doing in his dissenting opinion was sort of using the incorporation theory that the US courts were using earlier. Then but that was the dissenting opinion, and the majority still did hold it to a sort of restricted meaning of procedure established by law and liberty in and of itself in Article 21. Then Manush moves on to talk about Karak Singh versus State of UP. So in this case, what happens is they're essentially challenging certain provisions which regulate domiciliary visits and police surveillance in the state of UP. So what the majority in this case did was broadened the scope of Article 21 to include procedural due process, and therefore struck down the provisions which intruded in a person's space without following the procedures, without following essentials of procedural due process, and but still retain the provisions on surveillance because they didn't recognize a right to privacy. What the majority did was that there was no right to privacy in the Constitution, and that cannot be read in an expansive, cannot read in liberty in Article 21 in an expansive way to include this right, and that only explicit rights mentioned in the Constitution can be protected under Article 21. But the dissenting opinion, what Subbarao did was actually use substantive due process to read in right to privacy in Article 21. So he stepped beyond and went to the sort of right to privacy cases era in the US, refer to those cases in the US context to sort of read in substantive due process in privacy. Followed by this, there was the Satwant Singh case, which was very interesting because what was in the sort of, they use a substantive due process clause to read in the right to travel in Article 21, and also held that the term liberty used in the Indian Constitution and the US Constitution is same, that personal liberty in the Indian Constitution is equivalent to liberty in the 5th and 14th Amendment of the US Constitution. But Satwant Singh was reversed in Govind versus State of Madhya Pradesh, where the court went back to the sort of restrictive reading that was employed in Karak Singh to only protect rights that are enumerated in the Constitution under the procedural due process clause of Article 21. But finally, with Maneka Gandhi, what happened was it actually incorporated the doctrine of substantive due process and the right to travel in Article 21. So what essentially Maneka Gandhi does is similar to what we see with the substantive due process clause in the US, is to be able to read in articles that are not explicitly enumerated in the Constitution, but are considered to be implied rights by the structure of our Constitution itself. So it expanded the scope of liberty in Article 21 to cover many rights. And that's what we see in cases post Maneka Gandhi, for instance, some of the cases listed on the slide, which is Confederation of Indian Alcohol Beverage Companies versus State of Bihar, which talks about the right to consume alcohol, or Nas Foundation versus the government of NCT of Delhi. Then there's KS Puttaswamy versus Union of India, which recognizes the right to privacy itself under Article 21, or Sheikh Zaid Mukhtiar versus State of Maharashtra, which talks about the right to food and the right of choice to consume any food as a part of Article 21. So this is just to give you the broad history of how Article 21 and the 4th and 5th Amendments have been interpreted by the judiciary. So with this, I thought we can pose two questions and sort of open the floor up for discussion. Is how do you think the two jurisdictions view personal liberty? And two, how have US and Indian courts expanded on this concept of personal liberty? So the floor is open. Anybody have anything to say, please raise your hands or put it in the chat box and we'll read it out.
Ma'am, you're muted. Did you call my name?
Yeah, sorry. Yeah, Walter, please speak.
Yeah. So answer the first question. I think the US conception of liberty is something that's how they kind of conceived their whole constitution itself. So they kind of began, the United States kind of began with the view of personal liberty that was already kind of well matured at the inception of the constitution, and it has kind of developed since. That's how I see it. But in Indian context, it was developed eventually, is how I understand it. And by the time Maneka Gandhi came and the other cases that have come recently recognizing various other sorts of ways of personal liberty, it has come in an evolving social context. So the court has kind of responded, okay, this is a good time to introduce this, and that's how it has kind of gone about. That's the way I'd answer the first question.
Thank you, Walter. So any other comments? I see another hand raised, or it's just Walter's. Any responses, any additions to what Walter said? Sort of starting point to think about this is the text itself. What do you think about the constitutional text itself? Do you see any conceivable differences or similarities between, say, Article 21, the 4th and 15th, sorry, the 5th and 14th Amendment? Ghanavi has said something in the chat box. I will just read that out, and then I see 2 raised hands. What Ghanavi says is that I think the use of the word personal as opposed to merely life and liberty shows that the framers imply that liberty not only meant free movement without undue restrictions, but allow people to exercise decisional autonomy in their everyday lives. That's actually a very interesting point, Ghanavi, and that's how we see cases have read in the concept of decisional autonomy, be it with Navtej and even in Puttaswamy for that matter. Yeah, Pratibha, you can speak.
The textual difference which I can see in both the jurisdictions is regarding something which we have discussed earlier as well. So if we see the US Constitution, it uses the word due process of law, whereas the Indian Constitution talks about the due procedure of law. So when we talk about the due process of law and the idea in US and the idea in India initially, I feel US Constitution granted sort of more amount of rights, or like it had a greater scope, which inculcated in itself fairness and the principles of natural justice as well. Whereas in the initial phase, Indian Constitution was quite restricted to the procedure. So in that way, I feel that US in a better way tried to ensure protection of substantive rights of individuals than India in the beginning.
Thank you, Pratibha. Before I move to Hari, just one point for all of you to think about what Pratibha said is that while, yes, there is that textual difference, courts have still managed to bring in that due process. So I will probably ask you to comment on that once we've heard from the others as well. Yeah, Hari?
Hi, ma'am. Am I audible?
Yes, we can hear you.
Ma'am, my question is with respect to prohibition and the 21st Amendment in the US Constitution and freedom of choice. We saw until 1933 there were prohibitions across the United States, and they saw that it did not change the public's perception towards alcohol, and it was costing the government billions in taxes. Hence, they came up with the 21st Amendment. But now in India, we are seeing Gujarat is already a prohibited state. Then Bihar has followed its lead now. So my question is, based on the 21st Amendment and what we have learned on the due process of law, freedom of choice, can India learn from the mistakes of United States when it comes to prohibition?
That's actually a very interesting question, and especially because one of the cases that were there on the PPT was the Bihar High Court judgment, which is actually upholding the right to drink in opposition to the Bihar law that was enacted in 2016. So if any of the students want to comment on this, that would be great to hear what you'd have to say.
Ma'am, I lost network for a bit. Could you please repeat the question?
Yeah, so what Hari was actually citing was the sort of prohibition regime that was there in the US, where many states had laws that prohibited consumption and sale of alcohol. And then because there was no effect of this, the law didn't really have any practical effect and actually led to political conflicts. It was later withdrawn with the introduction of the 21st Amendment in the US Constitution. And he talks about similar prohibitory regimes that are starting in India, one with Gujarat as the prime example of regulating alcohol consumption. And we do see other states following suit. So how do we look at then this concept of liberty and due process when we see a failure of regime that was there in the US and that is being adopted in India?
If I may, ma'am.
Yes, please.
Yes. So hi, I'm Prithviraj, and caveat, I also live in Gujarat. So I'll also speak from that, my personal experience of the effect of the prohibition on ground level. So firstly, speaking constitutionally, the major difference between the US and the Indian to repeal prohibition, and here the Gujarat as one of the prime states which is enforcing prohibition, academically speaking, the DPSP difference is one of the major thing that we'll have to think, because here we don't only now have 21 recognizing privacy, and also not in absolute terms, by the way, but we have a 47 which says that the states must endeavor to prohibit on those lines. So first we need to consider that balance and the DPSP thing. And the second practical reason and effect of prohibition as far as that is concerned on ground in terms of public order, etc., then I believe that it does really create a practical difference. And I mean, publicly, I mean, personally speaking, everybody knows that if you are a good, you have good context, then you can still get alcohol in Gujarat. But the difference is that you cannot openly do so, because then you'll be put in jail. So you have to hide and do so. And that has, to a certain extent, helped in creating that law and order effect in Gujarat. And even the women protection effect is there. So there is that. And currently the Prohibition Act has been challenged in the Gujarat High Court. And the petitioners, they argued, they relied on Puttaswamy and all the post-Puttaswamy jurisprudence itself to claim that you should allow in our own homes. And the state argued that the state has told that the High Court cannot even listen this case. So that is a pending thing. But I believe that prohibition has its benefits as well if it is implemented in a good, effective manner.
Thank you, Prithviraj, for that. Any other comments about, especially going back to maybe what Pratibha said about the textual differences between the two? But if you do see how courts have sort of adopted a similar understanding of liberty and due process in both the Indian and US context.
Ma'am, can we look into this sort of restrictions or prohibitions from the angle of reasonable restrictions? Because even though all these fundamental rights, including the right to liberty, are granted to all the citizens, but these are not absolute rights, because there are other co-citizens or like the other people also there in this society, and we need to take care of their interests as well. So to ensure rights of some people, we need to curtail liberties of their cohabitants or like co-citizens, so to say. So in that sense, can we say that to maintain public order or to sort of impose reasonable restrictions, liberties can be curtailed to an extent?
Yeah, as we do understand the right to liberty, and even the following rights from that are read into that are not absolute, as highlighted by Prithviraj also about the right to privacy, which actually brings us to another interesting point that Walter had raised in the chats, which was about the right to property, and how in the US, even the right to property is read into the concept of liberty, but in India, it's restricted. And these restrictions also come from a sort of political, sort of socio-political climate. And that's why we even see the sort of need to have a directive principle, which is talking about regulating consumption and sale of alcohol, or as it terms, intoxicating liquor. So it's interesting to understand how the political context in US and India have also led to how these how a sort of seemingly similar article has been interpreted in two different manners in India and the US. Mihir, you have something to say, please.
Yeah, I can just add a small point about how in the US, like liberty is sort of connected to property by talking about one of the cases the US Supreme Court decided before the Civil War, which was Dred Scott. And it's interesting to note there that there they considered liberty to mean that slave owners can maintain property of their slaves even after they cross into a place where slavery was abolished. So that kind of attachment to property often leads to unjust, conclusions.
Thank you for that, Mihir. And maybe taking on from that experience is probably why we also have a limited understanding of liberty. And as mentioned, that we did want to bring in sort of laws that focused on redistribution of income and wealth and property. So having a sort of expansive meaning of liberty and letting courts adjudicate on this would hamper some of these socioeconomic policies that the government wanted to bring in. So maybe another thing to think about is the shift of judicial attitudes itself. So where we see from state of Gopal versus state of Madras, where they're adopting a very strict original intention, textualist approach to understanding Article 21, to a sort of more expansive understanding in Maneka Gandhi and the sort of trajectory it has taken, and the sort of reliance that this trajectory has had on US constitutional history and practice is very interesting to look at. And you could even look at the sort of timing in which Maneka Gandhi comes, which is right after the emergency when the Janata Party is in power, and the Supreme Court sort of felt that when its hands were tied, so-called, during the emergency era, felt like they sort of have the freedom to step in and go for a more expansive interpretation and, have a more expansive check on the other two organs of the government. Any comments on that?
Ma'am.
Yeah, Prithviraj, go first.
Someone was speaking, I guess. Someone else was.
No, please go ahead. Please go ahead. Sorry.
Yeah, thank you. So I'll just like to make one observation regarding the difference between the US and India in terms of what ma'am has said, the interpretation. Like if we look at the Puttaswamy and post-Menka jurisprudence, then the Indian judiciary more or less has consistently gone towards the transformative constitutionalism path, wherein now they are interpreting expansively and with intention, and are also activist, or I'd rather say in some cases hyperactivist as well. Whereas if we look at the United States, then there is this stark difference and this competing conservative legal versus the liberal legal movements going on, wherein, let's say today also, their Supreme Court, six of the judges are, and many of them, including, let's say, if we look at the example of the Lawrence v. Texas case, then Justice Scalia and the Thomas dissent explicitly says that there is no right to privacy in the US constitutional text emanating from, and it is not for the unelected court members to do these kind of reforms, but only for the legislature and the states alone. So if we look at if we compare, then the Indian judiciary has at the time gone consistently and as a whole towards this path of more nuanced interpretation in terms of transformative constitutionalism. The United States still, and I'd rather say post in the last year's legal development, more so the debate between the conservative and the liberal legal movement is getting more head-on collision. And in more times to come, like the Dobbs hearing, which is all set in 1st December, we'll see that this interpretation of the Constitution in terms of the liberty and the 14th Amendment clause there is a stark debate and difference as compared to our judiciary, which has consistently accepted it over the time.
Thank you, Prithviraj. Walter, you wanted to say something?
I think Prithviraj kind of covered what I wanted to say. So yeah.
All right. Okay. Anyone else have any comments?
I have a question though,
Yes.
which relates to presentation. So when you said the incorporation strategy which the US Supreme Court did, right? Kind of similar parallel to what Fazal Ali did in the A.K. Gopalan judgment. I was not able to follow how exactly the parallel made shape, because if I understood it right, in the US case, the states don't have an explicit charter of their own. And this 14th Amendment due process was kind of read. It was kind of read into it. I mean, I wasn't able to follow it properly. So I think it'd be good if
I'll just repeat myself. So in the incorporation theory, what essentially happened is after the Supreme Court said that the Bill of Rights apply only to the federal government and not to state governments, what they essentially did in the subsequent case is to sort of read in the Bill of Rights into the due process clause of the 14th Amendment, which applies to states. So the 14th Amendment, we know, explicitly applies to states. So what the Supreme Court did then is to what the Bill of Rights that was so-called not applicable to states, read it into the due process clause of the 14th Amendment. Similarly, what Fazal Ali does is, yes, 19(1)D has restrictions. So if the law passes good under those restrictions, it's fine. But if I have to read in the concept of freedom of movement into Article 21, I'll have to do it through incorporation. So what he does is he reads in the concept of freedom of movement, which is mentioned in 19(1)D, into the concept of liberty mentioned in Article 21. So that's the sort of similar incorporation that they do, where their rights are already enumerated in the Constitution. They're incorporating it into sort of broader conceptions in other provisions. Does that give you clarity?
I get it now. So it's like there are provisions in the Constitution and they are kind of being read into one another.
Exactly.
Got it now.
Yeah.
And
that if you contrast that to the sort of substantive due process one, where they're reading in this idea of implied rights, which are not even enumerated in the Constitution. So it goes beyond the incorporation theory. I think if anybody else have any further comments, please put it in the chat box. We'll try to address it. So we'll move on with the session and I will hand it over to Kalyani to take us through the two cases.
Thank you, Meenakshi. So I'm going to quickly take you through two cases, one Indian and one US, which also talks about the concept of personal liberty and specifically the right to marry. Once the slides are on, I can start with the brief. No, please take your time. Yeah. Cool. So the first case is Loving versus Virginia, which is a 1967 case. Over here, so I'm going to take you through the facts, the procedural history really quickly, and what the court held. The case arose after a white man, who is Richard Loving, got married to a woman of mixed African-American and Native American ancestry. So they traveled from their residence in Virginia to Washington, D.C. to get married. And on reaching Virginia again, they were staying at their parents' house and the police entered their bedroom in early morning hours and arrested them for having violated the state's ban on interracial marriage. The Virginia State Court sentenced the Lovings to 1 year in jail, but suspended the sentence on the condition that the couple leave the state immediately and not return as husband and wife, man and wife, for a period of 25 years. So they then established residence in Washington, D.C., and they filed a suit in the Virginia State Court seeking to overturn their earlier convictions. The court relied on a decision based on a case called Nime versus Nime, where the appeals court ruled that despite the statute's use of racial classifications to define the criminal offenses in question, neither statute violated the guarantee of equal protection of the laws because the penalties they imposed applied equally to both white and colored persons. So, of course, they did not get the judgment that they wanted, and then they appealed to the Supreme Court. That's how this case comes to the American Supreme Court. The Supreme Court actually has a unanimous judgment, 9-0 for the bench that was giving the judgment, where they reversed the Virginia State Court's convictions. The Chief Justice Earl Warren, who wrote for the entire bench, dismissed the 9 courts' reading of Equal Protection Clause and declared that we reject the notion that the mere equal application of a statute containing racial classifications is enough to remove the classifications from the 14th Amendment's prescription of all individuals' racial discrimination. So Warren's opinion was notable for its affirmation of the freedom to marry as one of the basic civil rights of a man. And he stated that it was fundamental to our very existence and survival. He also cited the Supreme Court's decision in another case called Skinner versus Oklahoma, where and then he also goes on to deny this freedom on so unstoppable a basis as racial classification embodied in the statutes. He says that it would, in a sense, mean to deprive all the state's citizens of liberty without due process of law. So the Supreme Court's ruling, of course, overturned the Loving's conviction and had the effect of invalidating laws against interracial marriages in another 15 states of America. The second case is an Indian case. I'll wait for you to, yeah, thank you. The second case is of Shafeen Jahan versus KM Ashokan. This is a relatively new case. It's a 2018 case. It's also titled the Love Jihad case. I'll again quickly take you through the facts. Hadia Jahan was originally known as Akhila, was Hindu by birth. She converted her religion into Islam when she was studying for homeopathy and then eventually got married to a Muslim man named Shafeen Jahan at the age of 25. Now, Mr. Ashokan, who is Hadia's father, found out that her daughter was inspired by somebody to change her religion from Hindu to Muslim. After finding out about the marriage of her daughter, he filed a police complaint and then moved to the High Court and filed a habeas corpus petition challenging the validity of the marriage on the ground of misleading and forcing his daughter to become Muslim. Hadia actually appeared before the High Court and stated that she had accepted Islam as a religion of choice. The Kerala High Court held that the marriage between Hadia and Shafeen Jahan was a sham and was of no consequence. And after 7 months, Ashokan filed another writ before the High Court, alleging that his daughter had been forcefully converted to Islam and was likely to be transported outside the country. And in this petition as well, the High Court ruled in favor of Mr. Ashokan and held that it's the father's responsibility to keep custody of his daughter, almost treating the daughter as an object, not almost, definitely treating the daughter as an object until she may realize her actions. The court, of course, exercises the parents' patriarch jurisdiction and mentioned that it is for the welfare of the child of such an age, although she was 25 years of age, and that even a girl aged 25 or 24 years of age may be exploited easily as they are weak and vulnerable. So the court declared the marriage as null and void, and because of the second petition, also allowed custody of Hadia to her parents, despite the fact that Hadia didn't, in fact, consent to it. So now this court was taken to the this case was taken to the Supreme Court. The Supreme Court set aside the judgment ruled by the Kerala High Court, declaring it null and void, and restored the marriage of Hadia and Shafeen Jahan. It held that investigations led by the NIA to probe marriage and other criminality can continue. However, it should not interfere with the marriage of two people. The 3-judge bench, which comprised of Deepak Mishra, Khanvilkar, and D.Y. Chandrachud, delivered the judgment. They removed Hadia from the custody of her parents against her will, and also sent her back to college because she had expressed her willingness to continue her studies. So in a sense, even in this case, the court upholds the right of the person to get married and the right to convert as long as it is consensual and not done by force. With this, I think that's enough to get a sense of what the courts have sort of stated on personal liberty, specifically the right to marry and conversion. I will read out the activity so that we know exactly what we're looking for from the discussions later. And then if there are any questions, you can pose the questions to us. We will then again, similarly, like in session 1, break you into 2 breakout rooms. And the one breakout room will talk about and discuss one viewpoint, while the other will do the other. I'm just going to quickly read out the activity. A state law is passed that criminalizes religious conversion solely for the purpose of marriage. The law declares such marriages as null and void and penalizes conversions done without the prior approval of the state. The relevant provisions are, first, Section 3, no person shall convert or attempt to convert either directly or otherwise any other person by use of misrepresentation, allurement, use of threat or force, undue influence, coercion, or marriage, or by any other fraudulent means. Second, any conversion in contravention of this provision shall be deemed null and void. Third, any marriage solemnized in violation of this law will also be considered null and void. Section 5, those in contravention of Section 3 would face jail term of 1 to 5 years and a minimum of rupees 15,000. So now, if this law is challenged between the Indian and US Supreme Courts, how would the 2 courts adjudicate this matter? Group 1 could decide whether the law would hold before an Indian Supreme Court, while Group 2 can decide if the law will hold before the US Supreme Courts. I would suggest you take a screenshot of the screen, because once we break you into the rooms, we might not be able to share the screen with all of you. If you have,
we can put up the, we'll put up the question in the chat box in both the private rooms, so you can have a look at it during your discussions. Okay, so in that case, what I'm going to do is I'm going to break you up into 2 rooms as we did in the previous session.
If you have any other questions, just put it in the chat boxes of either breakout rooms as well. One of us will probably monitor the chats. Maybe we can start with break room 2 this time in that case. Break room 2, could you tell us if the provisions would hold in the US Supreme Court?
Yes, ma'am. So whatever has come from our discussions is that except one of the speakers, the majority of them have agreed, that the US Supreme Court will strike down this law as unconstitutional, mainly for 2 main reasons: as violating the 14th Amendment's due process requirement, the right to marriage and the right to privacy, and secondly, the free exercise clause of the First Amendment. So first explaining the First Amendment justification, the US Supreme Court will apply the strict scrutiny and the undue burden test, and it will hold that this statute not only provides for prior permission or prior approval of state before conversion, in terms of conversion before marriage, solely because of marriage, as well as penal provision in contravention thereof. There is no compelling state interest to do so. That's what the US Supreme Court will judge. And even if there may be, then this statute will not, it's not narrowly tailored. So anyways, it will fail foul on the second leg of the strict scrutiny test. And it will also, for that matter, create a chilling effect, because now you are creating impediments for free exercise of religion, and the state is making inroads to that personal decision of what religion one may follow or not follow. Going on to the second leg of the justification regarding the 14th Amendment, what the US Supreme Court will rely on Loving v. Virginia that ma'am discussed, as well as the same-sex marriage case of Obergefell, and go on to say that the right to privacy and the right to marriage emanating from the 14th Amendment's due process clause provides for and recognizes an intimate choice between those 2 consenting adults, and that individual autonomy is something that is sacrosanct, and it is not for the state to again make inroads and say that, hey, you'll have to come to us, you'll have to seek permission, and if you do not, then you'll have to pay fine and go to jail. So again, the US Supreme Court will say that this contravenes the 14th Amendment and the precedents of the US Supreme Court as well. And then there's one more argument that such a law is, it can also violate the Equal Protection Clause, because there's no the differentia is not justifiable, because it only says that when you are converting for marriage, that then you'll have to come to us. So this only for marriage you are telling that you have to come. So why not then other conversion, if conversion is such a big an issue for you, the state? So the equal protection and the intelligible differentia argument can also be canvassed by the court. So these are the two main points.
Thank you. So in all, I would assume that the group thinks that the provisions would not hold before the US Supreme Court. But I just had one question. If it's possible, could you maybe just expand a little more on what you meant by how it won't stand the test of equal protection and intelligible differentia, especially when it comes to the marriage bit in the provision?
Yes, ma'am. Mihir, if you want to answer this question, then go ahead. Or I'll, because it was his point actually. So he might
that's fine.
Better placed to answer the question.
Yeah, sure. We hadn't discussed it in detail, but the main thing was because it specifically on grounds of religion, it's prohibiting people from it's placing a burden on someone to receive permission and potentially face imprisonment if they haven't gone through all of these processes. Then that sort of burden means that there's no on the grounds of religion means that there's no rationale for that, because there's no connection between the religion and that sort of burden being placed on them. So that was the argument we're trying to make.
Thank you. Is there anyone from group 1 that could highlight what their view is?
My name is Kaushik. I'm from School of Law, Christ University. And I'll talk about why such a provision would be unconstitutional before the Indian Supreme Court. So first of all, I would like to thank group 1 for giving like a very lucid discussion on why it would be unconstitutional. So what we basically discussed was number one, if we see through Article 21 itself, right? So we see that even this case, what we discussed right now, held that the right to marriage is a core and intrinsic part of Article 21. So this would be like one ground for the Supreme Court to strike down the law itself, saying that it's a violation of fundamental right. And we can also talk about how the right to decisional autonomy has been held to be intrinsic to what do you say about the right to privacy by the Supreme Court in Pottaswamy. So we can talk about how whether the law meets the standards of care that has to be held in Pottaswamy. Is it proportional? Does the state have a legitimate aim? And whether there are procedural safeguards present. So what we can see by reading like the section itself is that it talks about how no person shall convert or attempt to convert either directly or otherwise by any other person by use of misrepresentation, allurement, threat of force, or undue influence. So what we can see is that these are very broad terms that can have very different meanings, like say under contract law, like even criminal law itself. So they haven't given like the standard of care that has to be shown, whether it is by the person who's accused under law, or is it like the state has to produce evidence. So this can be one another ground for the Supreme Court to strike it down. Then we can also talk about the doctrine of repugnancy, because the problem states the state law, and we can see that marriage falls on the concurrent list. So we can talk about the constitutional implications on how, say, this law will be in conflict with marriage under the SMA or the Hindu Marriage Act, and if there is irreconcilable differences, the Supreme Court can strike it down. We've also talked about, we also discussed about how the right to a choice of marriage itself is a core and intrinsic choice that has to be made by an individual, which is a fundamental right and also a part of right to privacy. So the very fact that the state itself is mandating like, prior assent to, regulate these sort of marriages is like very, what do you say, it is very infringing by the very action itself. Then we also discussed about how Article 20 has an implication here, because we see it in the Indian Constitution and say even like in the US Constitution, you can only be held liable for a crime that has been committed when a law criminalizing offense was present when you committed the offense itself. So we can talk about double jeopardy and ex post facto laws itself. So, and we also discussed that lastly, in any case, the Supreme Court holds like such law to be constitutional, it would held it, it would like probably say hold it with like some limitations and make sure it applies prospectively and not retrospectively.
Thank you, Kaushik. Is there anyone else who wants to add to that from group 2?
Hi, am I audible?
Yes, Dhanavi.
Yeah, another point which we discussed was that before talking about the fraudulent means, misrepresentation and all of that, there's one clause which says that conversions without the prior approval of the state. That is one thing we found problematic in that act, because it is left to the individual what religion they wish to follow. So if he has to take prior approval from the state before converting, then we thought that was problematic and that wouldn't stand the constitutionality test.
Thank you, Kanvi.
Hello, am I audible?
Yes, Sanjana.
Yeah, so also to add on to what Gandhi said, we also discussed how the state is only going to regulate these forcible conversions or misrepresentations or fraudulent conversions. I think that there is going to be a very arbitrary standard of deciding that, unless we lay down precise standards of how we're going to determine what is fraudulent or what are these forcible conversions. I don't think that has been clearly defined, and that's something that we discussed to be extremely problematic, because it's going to be left entirely to the discretion of the state to decide whether these marriages are inherently forcible. And like Kaushik has also mentioned, like the part of evidence, how are we going to procure this evidence, whether the person that is engaging in the marriage, do they have to provide evidence to show that this is not a forcible conversion and this is something that I've done with the consent of my something that has happened with the consent of my partner, or whether the state also has to step in and show that this is a marriage that has happened out of force. So I think these standards are very arbitrary, and it's not possible to define or is it just going to be any marriage, like for that matter, any marriage that has a conversion, are they going to come before the state and then seek approval? So those are also questions that we kept in mind while deciding, and thought that was extremely arbitrary for the state to step in and decide how a person's marriage should be governed, or religious affiliation for that matter.
Yeah, that's a great point, Sanjana. And even about the subjectivity of the terms that are used in the provision itself is actually a very important point, because at the end of the day, there wouldn't be a clear definition as to what would then be defined as forceful conversions. Yes, Walter, I see your hand is raised.
Okay, so I think Sanjana got me thinking a little bit more, and from what you said, the provisions can be interpreted in any way, but then it just got me thinking on the main thing about marriage itself. Why is it required that we go get our marriages registered under the different laws? What was the rationale behind enacting a central law which asked us to get registered under Special Marriage Act or Hindu Marriage Act and so on? The reason that I can straightforward think of is probably because there are some state-sponsored benefits out of it. In case something goes wrong, the state's going to come in and protect. So I think if we apply that reason, and this is probably a justification that people who were drafted the law will also come to eventually, they say that this is just an extension of the state's duty, because you're registering a marriage under the state. This is just an extra step that we're getting in the way. I'm not sure how that works in the US. Maybe you guys, people who know here can kind of tell how the marriage laws work, or is there like a similar institution like in India? But this is something I just kind of noticed. So if the state is there as the monopoly body which can register marriages, then this is something that it can also extend and seek its function. How I'm getting this analysis, I'm not coming from Indian jurisprudence here again. I'm just thinking of that US case that I think one of the presentations previously was kind of said, right? In the due process presentation, state can pass laws to protect the health of people, but in this case it didn't. So that's the reason, that ratio is what I'm trying to apply here. Playing the devil's advocate again.
Thanks, Walter. If anyone wants to respond, I already see Pratibha's hand. Maybe we can let Pratibha speak, and then if anybody has anything to say about Walter's point, please feel free to raise your hand.
Ma'am, I have a doubt and a sort of a different answer also to this question, because even though the description to the law says that approval is needed from the state, but if I look at the provisions, the bare provisions, that is section 5 and section 3, section 3 nowhere specifically talks about the approval from the state. And looking at this bare provision with the sort of idea which has been propounded by Supreme Court in earlier cases, or in the case of Shafeen Jahan, it has basically talked about, and it has basically protected the ability of each individual to do whatever they want to. So when we look at these decisions, the core idea boils down to the individual choice and freedom, which is done out of one's own willingness and is not influenced by any external force, is something which is the crux here. So, and like with this ratio, if you look at the section 3, it just prohibits those conversions which are made because of misrepresentation or threat or other reasons, which basically shows the absence of a clear will from a person's side. So from that perspective, if you look at these provisions, I don't think they are problematic, because they basically just try to uphold that whatever you're doing, even if you're converting, it's fine, but that should be out of your free will. If your partner is coming and influencing you or misrepresenting something or threatening you to convert, then it is not fine. So I think this provision syncs with the interpretation which has been followed by Supreme Court of India.
Thank you, Pratibha. I just wanted to post just one part of the section which actually says that the section 3, the first clause actually says that even an attempt to convert for marriage will in fact be penalized. So do you think that would still fall under the idea of it being misrepresentation, fraudulent, or by coercion?
So will attempt here mean like trying to influence a person to convert himself or herself? What do we understand from attempt exactly? Like, is it the process in which you are sitting to convert a person and then someone comes and stops you in middle of that process? So if that process is carried out without will of the person who is getting converted, then I think that should be stopped.
Okay, understood your point. I believe it's, at the end of the day, it would boil down to the consent of the very person who is converting.
Yes.
Thank you. Are there any more people who want to raise a point?
Yeah, just to get a clarification as to what Pratibha meant. I think I'm a little confused, because I don't think section 3 by itself is inherently problematic. I think the problem arises when you say that without the prior approval of the state. So I think there is more clarity required as to the procedure in this case, whether it's going to be based on if someone is going to go before a marriage registry and like give a complaint saying that someone coerced me into converting to another religion, or whether the state itself is going to step in for every marriage that shows that someone has been converted. I think it depends more on the procedure of how it's going to go about. And yeah, so I think Section 3 by itself would not be problematic as long as the definitions of each of these terms that are being mentioned are properly defined and the standards are not arbitrary, and how the state is going to go about this is properly laid down. So I think the Supreme Court might hold this constitutional if it is supplemented with extra guidelines as to how the procedure is going to go about.
Understood. So probably depending on how it is interpreted by the legislatures and the courts, and also creating a definite understanding of the terms that are used in Section 3 would then give clarity on exactly what would fall under Section 3. Okay,
Yes.
I think, yeah, is there somebody?
Yes, ma'am. Just to put two supplementary points, one regarding registration of marriage and second regarding Sanjana's point of more clarification. Registration of marriage, the reason for compulsory registration of marriage has been discussed by the Law Commission in one of its report, as well as the Supreme Court has argued for compulsory registration, mainly for two reasons: that to avoid and protect women who suffer due to fraudulent marriages, and women and children who are out of the wedlock of fraudulent marriage, because the husband will then disown them and say that the marriage never happened. So that compulsory registration will help there. And secondly, to counter the menace of child marriage. So these are the two main reasons why compulsory registration of marriage is required in India, and it has been backed by both the Law Commission and the Supreme Court. And just to supplement Sanjana's point, the similar situation happened in the Gujarat High Court, when the similar freedom of religion amendment, and it's a similar clause that we have, the Section 3. So the state there was arguing the same, that it's not only marriage or attempt to marriage merely, but all the fraudulent and other indications that are there in the section. And then the High Court said there and there itself that that is what you are interpreting, but that's not what your statute or your rules are saying explicitly. And the police may just register an FIR and arrest the person. So the High Court then stayed and gave a clarificatory order regarding the same. So that is correct, that we need more clarificatory rule regarding the same, then this might be upheld. But in its vague terms, it's problematic.
Thank you, Prithviraj, for summing up those points. I think with this, maybe we can come to an end to the discussion that we had in this session. It was actually very interesting to see how both sides, I feel like we had different viewpoints on both sides, as well as different viewpoints from within the same break room as well, about how we all agree that the right to marry and the right to convert consensually is, of course, core to the right to privacy as well as other fundamental rights. However, the section does not necessarily give clarity as to how these terms will be then interpreted, and are highly subjective and so could be misused. However, in case they were more definite and objective, then maybe such a provision might in the future be a valid provision before the two courts. With that, I think I will move to the next part of our session and introduce our speaker for the session. Advocate Jayna Kothari is senior advocate Jayna Kothari is the co-founder of CLPR as well as the executive director of CLPR. She's a senior advocate and practices in the Supreme Court of India. She has argued in multiple landmark cases, including recent constitutional challenges to Section 377 and adultery, which are both decriminalized. She also argued in the Independent Thought case, in which the Supreme Court recognized child marital rape as a criminal offense. Her book, The Future of Disability Law in India, was published in 2012 by Oxford University Press. Advocate Jayna's research and practice interests include constitutional law, gender and sexuality law, disability rights, and discrimination law. Jayna, over to you.
Thank you, Kalyani. Thank you for introducing me. And I was listening to some of the conversations just a few minutes ago. And so I think all of you have really dived into both the cases and looking at both US and Indian constitutional provisions. So before I start, I just want to actually take off again on a few things that were raised on issues of registration of marriage. I know that some of you raised the question that why should there be registration of marriage, and I think someone answered it as well. But some of the important issues that have been questioned while registration of marriage may not per se be problematic, there has been a questioning, at least in the Indian context, on the requirements that are there for registration of marriage. For example, the Special Marriages Act requires that there should be a 30-day public notice given by the couple who want to register their marriage. And it's precisely these aspects of registration which have been challenged constitutionally as violating the right to privacy of persons, because this would, especially in cases of intercaste or interreligious marriages, this would intimate the family members and others who may want to oppose it. And so this is pending constitutional challenge in some of the high courts. Just to kind of go back to your previous discussion. And on the issue of, such a law that you all were debating now, I have written a piece which looks at the right to freedom of religion and marriage equality. And if someone's interested, I could share it. But what I'll do in the next few minutes is really try and compare some of these issues raised on liberty, privacy. I mean, your overall discussion has been around personal liberty and privacy in the context of marriage. And I'll try and look at a few more ideas, how they were raised. What were the issues that the US Supreme Court raised in Loving versus Virginia, and what were the, in contrast, how were the issues addressed by the Indian Supreme Court in Shafin Jahan versus Ashokan, and just some points for us to think about. So in Loving versus Virginia, you know the case. And those who haven't read the judgment, I hope that after this you take some time to go and read it. It's a short judgment. The case was concerning a law, a state law, which prohibited interracial marriages. And it not only prohibited interracial marriages in the state, it also, and made the marriages null and void, and made it a criminal offense on the people who got married, but also made acts of, for example, the couple going outside the state to marry and come back, also a criminal offense. So it's a bit like the example of the anti-conversion law that you discussed today, and which is also similar to some of the anti-religion conversion laws that are there in some states in India, like the UP law, which in fact prohibits conversion for the purpose of marriage. And so in the US, these laws, these similar laws like this, when they were enacted, they were called anti-miscegenation laws, basically laws that prohibited interracial mixing. Okay, now when this case went to court, what did the US Supreme Court do? How did it decide the case? I mean, it set aside the statute. I mean, it said that the statute is unconstitutional, but that's not it, right? What were its reasons and principles for holding that? So first, it's interesting that though, and this is where the US Supreme Court analysis differs from the Indian Supreme Court analysis in the Hadia case, is that the court, though it looks at it as from the point of view of liberty, the right, the freedom to marry, and therefore a liberty and freedom right, it looks at it from the perspective or angle of equality. So it first discusses whether I mean, the core reasoning is whether such a law is against the principle, the guarantee of equality under the 14th Amendment in the US Constitution. So that is the test that the US Supreme Court adopts. That is this law a violation of the 14th Amendment? And in order to examine that, the US Supreme Court raises the question that an argument is made that no, this is not a violation of equality on the grounds of race. It's not discriminatory on the grounds of race because all races, black or white, would be punished equally if they were to marry another person from a different race. So it doesn't just penalize African Americans, but it also penalizes white persons equally, so therefore there is no racial discrimination. So the court rejected such an argument, saying that just because it applies equally, it doesn't mean that there is no racial discrimination and that the law is equal. It in fact holds that the law discriminates on the grounds of race because it prohibits someone, it takes away their freedom to marry, which is a civil right. It takes away the freedom to marry solely on the basis of race. And in the US constitutional principles of reasoning, there on some criteria, there's a principle of strict scrutiny which has been developed. Such a principle is not there in the Indian, in our constitutional jurisprudence, but in the US constitutional jurisprudence, there is a principle of strict scrutiny. And this principle basically means, or the court has evolved it to say that some criteria of discrimination in legislation, for example, race or sex, these are certain criteria which are, if a legislation has a criteria which is based on race or even sex, it is a criteria which the state would have a heavier burden to justify. And therefore, the court will apply a stricter form of scrutiny to scrutinize these. And this and any classification, it does not mean that you can't have a classification, but then the state has to justify it, that this classification would not make the act discriminatory. And so it's called a suspect classification, and therefore the court will review it with a higher level of scrutiny. And so and this is a principle that is not there in the Indian constitutional jurisprudence. So I think it would be interesting for you. It's useful for us to examine some of these principles or forms of analysis. And so the court finally said, and when it examined the legislation which prohibited interracial marriages, the court kind of examined it from that strict scrutiny principle and said, what is the purpose of the state to prohibit interracial marriages? What is the purpose? I mean, the only criteria is race. And why is the freedom to marry, which is a fundamental right or a fundamental, it's your right to live, or your liberty and right to liberty and freedom and due process. Why is this taken away on the ground of race? Is there a justification for it? And the court reached the conclusion that there is no justification. There is no, the state could not justify why it restricts its freedom to marry solely on the grounds of race. And because it couldn't justify it, the court held that this was actually a violation of its the Equal Protection Clause. So we see the link, though we see the freedom to marry, the right to marry as a freedom and liberty issue, we see how in this case the right to liberty and privacy was not raised, but the right to liberty and due process is actually linked very inextricably with the right to equality. And from here, I would like to kind of move on to the Indian context. And if we contrast some of the, if we kind of try and look at the statute, the interracial statutes, perhaps in the US, I don't know when it was in the 50s or even prior to that. And we compare them to some of the legislations now introduced in some of the states, which prohibit interfaith marriages if it is done for conversion or by fraud or whatever grounds that are there. They seem quite similar, with the difference being that the prohibition is on the ground of religion instead of race in the Indian context. And so the question I would like to raise, and this is what I have actually written in some of my in a couple of pieces that I've written, is that is this just, and do these legislations raise just a restriction of marriage on the ground of religion, which they certainly do, but they're also a restriction on one's right to equality, because it amounts to curtailing of one's freedom to marry unequally as compared to others, solely on the grounds of one's faith. So moving on, let's look at perhaps, in the light of this, some of these ideas, let's maybe look at the Shafin Jahan case. Certainly in the Shafin Jahan case, such statutes prohibiting the right to marry were not there. So there was no, I mean, if they were there, certainly they would, it would have amounted to a violation of those laws, because she did convert to get married. But anyway, those statutes were not there. But how did the court decide her case, and what were the principles and rights that the court considered in the Shafin Jahan case? And it's interesting that the principles used or were on the right to life and autonomy, and the court held that there is the right to life under Article 21 includes the right to marry. And so I think one of the most important things was such a declaration that the right to marry is a fundamental right under Article 21. And it also held that the right to privacy, which is also included under Article 21, includes the right to choose one's partners, to make intimate decisions regarding one's personal life, all of which are examples of all of this, which which include deciding who to marry, and also to decide one's faith. Including conversion, if one decides to do that, because these are all very personal, intimate decisions. The right to make intimate personal choices was also seen as an integral part of one's right to privacy and one's right to life and the right to autonomy. So these were the principles that the Indian Supreme Court used to say that the decision of the High Court in annulling their marriage was illegal, was wrong, and it upheld their interfaith marriage and held that she's an adult, she has the right to decide what to do, and that her freedom cannot be curtailed, her right to autonomy cannot be curtailed. But importantly, I think an important omission that the court made is that the court did not examine if there was any violation of the right to equality. It looked at it as a freedom, liberty, and a privacy issue, which it certainly is, but didn't examine it as from the aspect of equality, that certainly this issue would not have arisen had Hadia married a Hindu man, and she would not have been treated this way or been prohibited from marrying, or her marriage would not have been annulled had the religion of her partner been different. And so we see the link of equality missing in the case. And so, so that's what I want to raise and maybe give you all something to think about. Thank you.
Thank you, Jayna. Thank you so much. Maybe I will now open the floor up for questions to Jayna. If anybody has any questions, please feel free to raise your hand or even leave them in the chat box. That way we can take both.
A hand raised. Ganvi? Yeah, please go ahead.
Good afternoon, ma'am. My question is with regard to the registration of marriages. In Richard Taylor's book called Nudge, he has proposed this idea that states should stop recognizing marriages and they should have only what is known as civil unions, and marriage should be left only for religions to do. So especially at a time when the question of same-sex marriages have arisen in India, do you think this can be adopted in our country? And if adopted, would it be constitutional?
Yeah, I mean, yes, of course, civil unions. Right now the demand in the country is for recognizing same-sex marriages. There have been some challenges filed in different high courts that marriage laws should not be restricted on the grounds of sex, opposite sex, and same-sex marriages should also be recognized. But whether it is, recognizing relationships as same-sex marriages or recognizing same-sex relationships in the form of civil unions, certainly I think within our present kind of context of our Supreme Court decisions, I don't think they can be challenged as being unconstitutional. We've had the Nafte judgment, we've had the privacy judgment, all of which uphold the right to, making your own personal choices and the right to privacy and life, including decisions on even if civil unions are recognized, there shouldn't be a challenge. The difficulty is that
Sorry,
whether,
Jayna, we lost you. I think your internet was patchy. Do you mind repeating the last two sentences?
Okay, can you hear me?
Yeah, now we can.
Yeah, can you hear me now? Yeah, so I was just saying, I think there's such laws may not have a problem in the courts, but the bigger challenge now is that are we in a situation where the government will actually introduce such civil union laws, where we are facing such opposition even to interfaith marriages. The chance of same-sex civil unions is a far cry.
Thank you, Jayna. There's one more question in the chat, which I'll just read out. It's from Hema. She says, ma'am, would it be a criminal offense in UP if I converted my religion for marriage in another state and then decided to reside in UP?
I mean, it's interesting. I don't think the UP law includes, I don't remember it very closely, but I don't think it includes a clause which says that, like the Virginia, Loving versus Virginia case, that even if you go outside the state and marry or convert and come back, it would still be an offense. But, the law is, at least the UP law is quite broad. It, who knows? I mean, it has to be tested. Right now, it's being challenged. The constitutionality is being challenged. So it has to be tested. But sometimes the danger with some very broad laws is that they may cover even some of these kind of instances,
Thank you. Are there any more questions or points that any of the students want to raise?
Ma'am, am I audible? I have a doubt regarding the equality point which was brought up by ma'am. So when we look at equality, and as you compared the case of a Hindu girl marrying a Muslim guy or a Hindu guy, we see a difference. But then how do we address this situation in light of the personal laws also, which demand a particular person to convert if they want to sort of marry or do anything with a person from that religion? So isn't that demand like unfair or like unequal when it comes to marriages?
In a way, yes. One can say that, personal laws, which, most personal laws, I mean, certainly Hindu Marriage Act requires that both persons marrying have to be Hindu. I think Muslim personal law also requires that you should be, both spouses should be Muslim, and maybe Parsi law does as well, that you have to convert or otherwise you can't marry. But the answer to that is the Special Marriage Act, right? Because we do have another law which does not require you to convert, and you can get married under a Special Marriage Act, or it's a civil law for marriage. And but yes, it means that one has to give up their religious personal laws, and those religious laws will not apply to marriage, so you have to take that step. And one can say that, well, I am being forced to give up my religious, if I am a believer and I do want my religion to be applied, then I don't have that choice. But then the one of the arguments made, and what the constitution also has, is that there would be a uniform civil code put in place. We've not had that yet, and so the argument has been for a very, very long time that there should be a uniform civil code which will address all issues relating to marriage, family, children, and all other issues coming out of marriage and family to persons equally, and which is not different based on their religion. But unfortunately, we don't have a uniform civil code yet.
I think there's one more in the chat, Jayna. Hima asks, wouldn't the introduction of the UCC remove my fundamental right to practice my religion freely?
Not really, because the idea of a uniform civil code, or even the special, the idea of the uniform civil code, or even the Special Marriage Act, I mean, the way it is, though there are certain problems that have been, attacked. The idea of the uniform civil code would be to only provide certain provisions uniformly to all persons, irrespective of their religion. It would not deprive you of you practicing your religion or adopting whatever religious practices that you may have. But right now, we have issues with regard to marriage, maintenance, and custody, which are quite different across different religious personal laws. So, for example, in and one of the main areas where these laws differ, personal laws differ, is in the way women's rights are addressed. So, for example, while in Hindu law and in the Hindu Marriage Act, you have certain rights relating to maintenance. In Muslim law, the right to maintenance is very, very different. You have something called, the meher, which is given. And and custody is quite different, custody of minor children. So it is, marriage is quite different. The process of marriage and divorce, I mean, more than the process of marriage, it's really the divorce. And some of those aspects were challenged. So it was really to unify. Sorry, I have a dog screaming. It is really to unify some of these provisions and to make them more equal and fair to women, that the Uniform Civil Code was argued for. And this would not curtail other aspects of personal laws that people would not be prohibited from practicing in any way. And there's another question that can the UCC address the issue of varying judicial stand of live-in relationships? I mean, I don't know, we don't have a UCC on live-in relationships. The judiciary has, there are some decisions which are not very clear. I mean, we do have the prohibition of the Protection of Women from Domestic Violence Act, which recognizes live-in relationships as well to address domestic violence. But in some cases, the courts have kind of looked at live-in relationships and the nature of marriage, especially in the context of domestic violence and other reliefs relating to, custody, etc. But there hasn't been a clear judicial finding whether live-in relationships are accepted or not. I mean, it is again only opposite sex, long-term live-in relationships, which in some contexts have been accepted, but not other forms. So can a UCC address it? Yeah, maybe it can. We have to revive the conversations on the UCC and then expand the scope to see that what all would the UCC cover.
Great, thank you, Jayna. Maybe I think since we're running out of time, we can end with that one question. Thank you for joining us for this session and actually giving us a very comprehensive understanding of how the courts in the two countries looked at the cases, one with respect to interracial marriages and the other with interreligious, and sort of tying it to the idea of equality. I think that actually added a lot to our previous discussion as well. Thank you for being a part of this session. With that, I think we can come to close with this session. I would like to thank our partnering law school, Tamil Nadu National Law University, Usha from the US Consulate, and all the students for attending this session. Our next session will be at 3 o'clock. So we have an hour-long break before the next session. The session will be an hour and a half, will end at 4:30. Please feel free to log off and log in back at 3. If you want to stay on the Zoom call, that's fine too. You can just mute yourself and the link should stay on. Thank you all for joining, and we'll see you soon.